Go ahead, Vice Chair.
Great, thank you. Good morning, everyone. We're going to give it a couple of minutes, not that long, but I see the attendee list is growing and people are coming into the room. Good morning. This is the Committee of Bar Examiners meeting. My name is Alex Lawrence, and I'll be subbing in for a short time period for the chair who was called to court this morning, but who will be joining us a little bit later. But I think we can at least start with a roll call from the State Bar. So with that being said, Ms. Wong, can you take the roll?
Okay, thank you. James Bolton.
Here.
Robert Brody.
Here.
Michael Cow.
Here.
Alex Chen. James Efting.
Present.
Kareem Gongora.
Present.
Dolores Heisinger.
Here.
Judge James Herman. Michael Iseri.
Here.
Larry Kaplan.
Here.
Paul Kramer.
Here.
Mr. Vice Chair, Alex Lawrence.
Here.
Bethany Pick.
Here.
Vince Reyes.
Here.
Judge Shelley Torriaba.
Here.
David Torres.
Here.
And then Dr. Don Wilkinson.
Here.
We have a quorum.
Great, thank you. So we have a good amount of items in our agenda today, but before we start, as was mentioned earlier, we have a new member, part of the committee, Dr. Don Wilkinson, who comes to us from Riverside, California. He's a Senate appointee. He's done some fantastic work as an educator for a number of years, serving as a professor, a dean in technical education. Very impressive resume and background. Dr. Wilkinson, would you like to say a few words?
I'm just honored to be here. This will be a new experience for me, and I'm looking forward to contributing and doing what I can. Thank you.
Well, welcome. We really appreciate you joining the committee.
Welcome.
And definitely going to be leveraging your background and welcome your input on a number of issues and items. So as noted in the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment are encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. We thank you for that. We will attempt to call members of the public in order that they appear. Due to the number of people requesting to make public comments, we ask that you limit your comments to 2 minutes. And to facilitate that, we're going to take as many comments as we possibly can. We encourage you not to repeat any comments or points that were made by previous speakers, and to allow the committee to the time to deliberate on the important topics we'll be discussing today. We're going to, as I mentioned, take as many comments as possible within the time frame that's allotted to us. For those who are participating via Zoom, you should have a function for virtually raising your hand. It's a hand icon and it should appear at the bottom center of your screen. I can see that some of you have already been using the feature, which is fantastic. But if you wish to make a comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. We will call members of the public in the order that they identify by raising their hands, and will enable the microphones of those speakers. So with that being said, we're going to start with the public comment, and I see a Rose Brooks who now has raised her hand. So Ms. Brooks.
Hi, yes. My name is Rose Brooks Sheila. I am an applicant for the February 2021 bar. As you may have already seen, there was a letter submitted by United Diploma Privilege for All regarding the acknowledgement and acceptance testing form that was sent out by the state bar using a third-party sender. So I registered for the bar on October 1st, the very first day you could register for the February 2021 bar, and paid my dues in full immediately. I began the moral character application, and I was involuntarily withdrawn after completing my application, after my eligibility being approved on January 15th. I also received an email on January 26th notifying me that my admittance ticket was ready to print. I obviously went to the site and there was no admittance ticket because my application was involuntarily withdrawn by the bar, notifying me that they would not be refunding the $850 that I paid out of pocket to register for the exam. This was due to a form that I did not know existed. It was sent by a third-party sender to my spam email inbox, as well as many others who are dealing with the same issue. Either they did not receive the email because there was a typo in their email address, or it was sent to spam because it was not sent from the standard email address that the bar was using, the State Bar of California email address. I'm here to plead with the State Bar and to let you all know how devastated and disappointed this group of examinees are for being involuntarily withdrawn by a form that was not made sufficiently clear that it was required for our application. There was extremely confusing communication coming from the bar, approving our eligibility, sending us admittance tickets. And so when we received the news that we were involuntarily withdrawn less than a month before the exam, needless to say, we were extremely disheartened, discouraged, and wondered what we could do to advocate for ourselves for missing a form that we did not know exist. I'm sure that other public members will be echoing this comment, and I thank you for giving me the time to speak today. Thanks very much.
Thank you, Ms. Brooks. Ms. Pilar Escontrias, and just for everyone, a reminder, I'll let you know when you're having about 30 seconds of available left or remaining. Ms. Pilar.
Hi, good morning, everyone. Thank you for giving us time to speak. I'm present on behalf of over or about 100 signatories to a letter that was submitted to this body last night, requesting that the State Bar of California extend some grace and extend the deadline for all applicants to submit the acknowledgements and acceptance of testing conditions waiver, which is due for some applicants on February 1st, but which was due for others on January 15th, thereby creating somewhat of a conflicting messaging even on the State Bar's own website. So it wasn't entirely clear where this form would be found, who would be sending it. This waiver was inadvertently delivered, as my colleague mentioned, to many people's spam inboxes, given that it was sent from a third-party sender. Whatever the reason for applicants' inability to submit the form by the deadline, the reality is that applicants have spent thousands of dollars in addition to bar prep, the $850 that we have to spend to the State Bar of California. This is an exam that's a necessary requirement for the practice of law. Individuals are not just being careless and not, responding and signing a form back. It's a very easy thing to do, to submit an acknowledgements and acceptance conditions form. And so those who were unable to submit it have at this point, we're unfortunately not sure how many people did that. So I formally ask the State Bar to also release the number of people who were affected, who did not submit their acknowledgements and acceptance of testing conditions. But we'd like to know, we're respectfully requesting that after these folks have submitted numerous requests to the State Bar and been told that they cannot take the exam now and have not been issued refunds, for this body to take some action. In advance of the October 2020 bar exam, the same thing occurred, okay? And many applicants were similarly affected, and the State Bar did the right thing, and you extended the deadline. This was compassionate. This was grace, right? And we're just asking the State Bar to do the same thing for February 2021 examinees. the same exact thing, to extend the deadline for the same reasons, unfortunately, because they have not been resolved for the February exam. This extension doesn't require any additional time on your part. It does not require additional capital being expended. And it simply allows for examinees who have already paid all of the fees and who are 2 weeks away from taking the exam to be able to sign a form. I don't think that's asking a lot. Again, we'd like to know how many people are affected by this. I'm sure the State Bar is well aware how many people are affected, and that's it. I'm here on behalf of 100 people. Hopefully you all will find some compassion and grace and extend this deadline for folks. Thank you so much.
Thank you, Ms. Contreras. Ms. Megan Zavia.
Yes, thank you. My name is Megan Xavier. I am a member of the Association of Disciplined Defense Counsel, and my practice is entirely devoted to representing attorneys and applicants before the State Bar of California. And like Rose and Pilar have already explained, there's a lot of examinees out there who were counting on taking this exam, and they're now stuck being told they're involuntarily withdrawn through no fault of their own. Now, online bar exams obviously present a lot of challenges, and those are both human and technological. But when human choices regarding the technology lead to problems, the State Bar of California should not abdicate human responsibility to fix those issues that were caused by those tech choices. And that's exactly what happened here. So I want to just explain a few things that haven't yet been covered. The first is, applicants could not submit this required form without the actual email from the bar. The email contains a personal link, and they have to use that link to submit the form. The State Bar's FAQs make it very clear. There's a copy of the form on the website. You may not print, fill in, and submit that form. That is not sufficient. So you don't get the email, you can't take the exam. Now, all other exam-related emails were received by these applicants. They come from admissions@calbar.ca.gov. They come from eligibility@calbar.ca.gov. This letter or this email does not come from that same email address. It comes from Salesforce. It looks like a phishing email. If you look at the actual email, it says online bar exam is the sender. And then in the string of the address, it's via a lot of numbers and letters at salesforce.com. So it wasn't just that applicants thought this was spam, their spam filters thought it was spam. And a lot of them didn't even end up in spam, they never got delivered. Now the State Bar chose to use this third-party app. Why? None of us know, but they made that choice. A human made that choice. And a human should have been able to log into the State Bar's dashboard on that third-party site and see that these emails weren't being delivered, that they were going to spam or they were being bounced. Now the State Bar's reaction to this.
Please wrap up your time. Your time is up. Can you just wrap up your comments, please?
Yes, thank you. I thought I was going to get 30 seconds for me. I apologize. The State Bar has said it's the applicant's responsibility. How could they possibly have responded to an email they never knew existed? So we just asked for the same grace as Pilar mentioned that was given in October. The State Bar knew of the problem and recreated it for this exam. Thank you.
Thank you. Ms. Lisa Hutton.
Thank you. Good morning to the committee. My comment is in reference to the proposed action in the Ed Standards portion of the agenda concerning John F. Kennedy School of Law's accreditation status and recommendation of probation. JFK School of Law respectfully requests the committee to postpone or suspend any decision regarding the accreditation status of the school, pending a complete and accurate accounting of graduates who have satisfied the requirements of the California Bar during the period covered in the 2020 NPR. It would be inappropriate for the committee to make an adverse decision affecting accreditation based on inaccurate, incomplete, or revised data regarding the actual California Bar pass rate for the reporting period in question. This request is made at this time based on the order of the California Supreme Court issued about 24 hours ago. And we make this request based on the following factors. Yesterday, the California Supreme Court issued an order retroactively expanding the pool of law school graduates who qualify as provisionally licensed lawyers. So those who graduated between 2015 and 2020 and who scored at least 1390 on the bar. Graduates from 2015 to 2020 who meet the requirements of being a provisionally licensed lawyer by scoring at least 1390 on the bar have in all effects passed that examination. The only step for them to gain admission to the bar is to satisfy the 300-hour requirement and the other standard processes. It's worth noting that the NPR statistics used to determine compliance with the accreditation standards are not based on admittance to the bar, but on passage.
You have 30 seconds.
Provisionally licensed lawyers, those who earned at least a score of 1390 on the bar and have successfully met the requirements of the California bar. All right, so prior to the new order of the Supreme Court, JFK's NPR for 2020 was 39.7. We believe only one additional graduate from that reporting period would be needed to raise it to 40% or above. We do know of at least one student within that reporting period in that position. If she were to be included in that
Ms. Hutton, we
reporting
ask that you wrap it up. I just want to be fair to the rest of the people who would like to make public comments.
Of course, I appreciate that. We also believe there are other graduates within the reporting period in that same position. Here's what it is. We are concerned that your interpretation that the graduates that fall into the provisional threshold count as a fail. This interpretation actually penalizes us. It is these graduates that would give schools the best chance of increasing their NPR once they retake the exam. But these same graduates will no longer sit for an upcoming administration because the Supreme Court has counted their scores as effectively passing. They will then begin to practice law as JFK grads, yet still count against JFK as failing within the 5-year window.
Ms. Hutton, I'm sorry for cutting you off, but again, going over the allotted time, I really want to get the feedback from other people, allow them to make public comments as well. So sorry for cutting you off, but I'd like to move on to Mr. Benjamin Cohn.
Hello, thank you. My comment is in regard to the concern about the staff time for testing accommodation appeals underlying the pending revisions to Rule 4.90. I wanted to point out the other ways in which staff time could maybe be made more efficient with testing accommodation appeals. I think one of the concerns is that some applicants need to do appeals over and over again and not limit themselves to one decision. And I think part of the reason for that is they need to include more information responsive to the last decision's reasoning, which they didn't know before was an issue in their accommodations. So having the process be more interactive initially might take more staff time the first time to get more detailed dialogue about the concerns and to allow them to talk to the doctors about more of the things that the doctors need to write about based on those concerns, but then it may allow the process not to repeat over and over and in the end be more efficient because you don't have to have it keep coming back up and have the applicant keep retaking the exam because of the time constraints of it keeping to come back up. I know that for the doctors, if they're not told exactly what concerns they need to address, they don't have time to speculate about every possible thing the bar may want to know. So they really do need the decision letters to address the concerns or the things that are unclear in order to know to write about it, because otherwise they have 20 to 40 minute appointment slots and they usually don't want to go over that.
Mr. Cohen, you have 30 seconds left.
Maybe this cycle was an exception because when they start hearing things like people need to test in person during the pandemic, then they start giving up their weekends. But until then, it is something that should be a little bit more interactive. I refer back to my written public comment about the rules, but if it was more live, more interactive, it would be less repetitions and it wouldn't keep coming back up most likely.
Thank you, Mr. Cohen. Mr. Timothy Weimer.
Thank you. I appreciate some time this morning. My name is Tim Weimer. I'm the Dean at San Francisco Law School, and our school is being considered today under the Education Standards sections of the agenda. And I would also like to make a few comments regarding the recent announcement by the California Supreme Court regarding the provisional licensing program changes. Let us remember the purpose of the bar exam is to ensure that a person seeking to practice law in California has the requisite knowledge to represent his or her clients competently. In other words, the exam sets the standards by which this can be determined. The Supreme Court has now changed that standard for a particular group of law school graduates. The court has determined that the standard for showing requisite understanding of the law is scoring a 1390 on the California bar exam. If this standard is met, a person may begin the practice of law with some oversight. The NPR statistics reported by the law schools used to determine compliance with accreditation standards are not based on admittance to the bar, but on passage of the California bar examination. To not acknowledge this fact by allowing law schools to adjust their NPR is a disservice to all California accredited law schools. Now, for sake of time, I'd like to just make one recommendation for the committee to consider as they discuss the issue of these recent changes. The committee could allow California accredited law schools to remove from the NPR any alumni who become licensed under the new provisional licensing program. In other words, graduates who become licensed attorneys under the new program and score mandates are simply removed from the calculation. This will reduce the denominator and accurately reflect the true statistics of the bar exam pass rates. This approach does not.
Weimer, yeah, 30 seconds.
Great. This approach does not allow California accredited law schools to retroactively add alumni. It just simply accurately reflects that some people did not have to take the exam to become an attorney. Let us not go back and recalculate based on the new score. Let us just accurately reflect that some people have become attorneys and shouldn't be accounted for in that score. I also respectfully request that any decision regarding compliance with the NPR accreditation standard be suspended until there's a full and accurate review of these new guidelines. Thank you for your time.
Thank you. Mr. Julian Sarkar.
Thank you, sir. Good morning. My name is Julian Sarkar. I represent attorney applicants and matters against this committee in the Office of Admissions. In the cost analysis report for today's agenda, the Office of Admissions complains about being sued for its practices. I'm hoping to present a proposal for remedying that on an issue I think that a number of people have been here today to speak about. Earlier, this committee was requested to provide information on the number of applicants affected by this committee's decision to take their money and then prohibit them from proceeding with the exam that they paid for, but keeping their money. This committee wasn't requested to provide any individuals identifying information, so that sounds like a request within the meaning of the California Public Records Act requiring a response in 10 days. I joined that request. At the last Committee of Bar Examiners meeting, the Office of Admissions claimed it specifically presented, put up a slideshow that I sent to this committee, a screenshot of that said it'd be sending applicants emails to access the acknowledgement acceptance from calbar.ca.gov. I've highlighted that in the exhibit that I sent to this committee. But after doing the cost analysis, I guess they realized that the profits are higher if they just keep applicants' money and prevent them from taking the exam. So they set up the Ames portal to prevent the applicants from signing the acknowledgement acceptance in the first place. And then they sent them emails from other strange domain names other than the ones that they stated that they would be sending it from, specifically at the last Committee of Bar Examiners meetings. And so many of those applicants' email spam filters did exactly what they were designed to do, which is protect the public from fraudulent email scams that come from weird domain names. So now the Office of Admissions
Mr. Sarkar, you have 30 seconds.
Okay, so I just want to say, if the whole point of the acknowledgement acceptance is to be able to get away with harming people, and not being sued for it, why not just let them proceed and sign it? So I call upon this committee to protect the public from this outrageous conduct by the Office of Admissions. Thank you.
Thank you. Ms. Lillian Miller.
Sorry, everyone, I'm here. My name is Lillian Miller. I'm an attorney licensed in Illinois, and I'm an applicant for the February 2021 bar. I was one of the applicants disqualified for failure to fill out the testing policies form that I never received, and so was never given an opportunity to sign. Now, the same problem happened before the October administration of the bar, and the Office of Admissions granted an extension to allow applicants to sign the form and take the test. So I was absolutely stunned when the Office of Admissions refused, for no reason at all, to grant this cycle's affected applicants the same remedy it provided just months ago. The fact that the same problem has affected multiple applicants 2 cycles in a row, and the Office of Admissions position is that its applicants are the problem, is beyond comprehension. It seems like the bar took absolutely no remedial action at all in response to the last time this happened, and it's baffling. Now, I have spent $1,300 and countless hours of work in reliance on the bar's promise to allow me to take this licensing exam. I have also been meticulous about ensuring my compliance with any and all requirements of which I was actually notified. This is evidenced by my many emails and phone calls with the Office of Admissions to ask questions. Now, I was contacting them frequently enough that I was concerned that they were going to start getting annoyed with me. And I've presented to the bar documentation of the frequency of these communications, many of them unanswered, all of them begging for clarification and assurance that nothing was missing. The fact that my obsessive attention to detail was not good enough here just shows me that nothing any applicant does will be good enough, because the bar can and will penalize applicants even when it is clearly in the wrong. And the most
Miller,
painful
you
part
have
of
30
this-
seconds.
The most painful part of this is that the bar could reverse this decision today at no cost to itself by granting the same remedy that it granted the last time, and it's just choosing not to. And it's disturbing that a body that is designed to protect the public and that controls my and my peers' ability to use our law licenses would treat people this way. And I'm asking you to do better and to represent the public in a way that is responsible. Thank you.
Thank you, Ms. Miller. Zian K. Toe. Mr. Ian K. Toe, are you there?
Hello, can you hear me? Sorry about
Yes.
that. My name is Ian. I was an applicant for the 2020 October bar exam, and until recently also an applicant for the February bar exam. I would like to ask the Committee of Bar Examiners to please grant an extension to the February bar exam applicants to fill out the necessary paperwork in order to take the exam. During the last exam, I experienced issues with facial recognition technology and subsequently withdrew at the urging of a technical support representative designated by the bar committee for the day of the exam. I did not realize that withdrawing would change my classification as an exam taker at the time, but regardless, during that time, I received instructions to withdraw and subsequently was classified as a first-time taker, denied a refund, and given conflicting sets of instructions for the upcoming bar exam, to sign up by the deadline of the exam takers or to sign up by the deadline of the first-time takers. I applied to the February exam despite being denied the refund, paying for the second examination out of pocket despite unemployment. I spent the last half year ignoring the trauma that came with losing my father to cancer and the stress of having a loved one working on the front lines of this pandemic as a nurse in order to study for this exam. And I was devastated to learn that myself and many others were withdrawn from the exam for failure to fill out a form that we did not receive and we could not even perceive upon accessing the website for bar applicants. This was a link that was only sent to our emails that many of us did not receive. While I understand that as applicants, we're supposed to be vigilant and check our incoming emails, there are often circumstances beyond our control, such as being sent emails from phishing companies, being inundated with emails from ads that have sprung up because of access given by ExamSoft. I was personally locked out from my email. Regardless of the circumstances, I request humbly that the State Bar please offer some compassion and grace during this time and extend the deadline for applicants to fill out the form, because myself and many others' futures are currently riding on this right now, and we're not trying to ask for money back or an unreasonable request. We simply want to sit for the exam that we paid for. Please help us.
Thank you for your comments. There is one labeled here as Zoom 5.
My apologies, that was the last login for my class. This is Laura Palazzolo. I'm the Dean of Lincoln Law School of San Jose. I'd just like to support the comments made by Ms. Hutton and Mr. Weimer. Some of our graduates have been essentially deemed by the Supreme Court to have passed the bar exam subject to supervised practice. They therefore won't retake the exam. And it seems to us logically that they must be either counted as a pass in the numerator of our bar pass rate or be removed from the denominator of potential takers in that bar pass rate calculation. And I would just ask that the committee delay action related to bar pass rates until how these graduates will be counted has been resolved. And I would our proposed disclosure, which will be considered later this morning, includes a detailed calculation, and if that may be affected by the Supreme Court's recent action, we would just ask that action be delayed by the committee until that calculation can be resolved. Thank you.
Thank you. I believe there are no more hands raised for public comment. I want to thank everyone for submitting those comments and adhering to the time. I'm sorry, there is one more, Ms. Kelly O'Hare.
Hi, good morning. I know some of you from working with you previously. I just wanted to bring to your attention that I submitted a letter regarding whether or not a registered in-house counsel applicant can practice law during the time that the applicant's appeal is pending before the board. And that you should have that. If you don't have that, please let me know. I'll send that to you. It took me a number of months to get that letter to you. I did submit it to staff and it was not sent to the board. I think that's a problem, which I want to bring to your attention. I have a number of issues that I've sent to this board that were not sent to the board by staff. And so I'm hoping that you will ask for that or address that. But this particular issue with the registered in-house counsel is not a policy. And I think the board needs to create a policy with the new process. Given that the new process is the staff are doing the Zoom informal conferences, there needs to be a policy on whether or not someone who is denied can still practice law while their appeal is pending with the board. And so I would ask you to form a committee to look into that or to create a policy. Second, I also submitted a number of changes to the moral character guidelines. I spent some time going through the guidelines. There are a number of legal nullities in there. And I think you need some help with a criminal law attorney to go through the guidelines. There are some things such as consideration of things like parole for city ordinance violations. Parole is equal to a felony. It's not a misdemeanor situation.
You have 30 seconds.
Okay, so anyway, I spent quite a bit of time going through and writing the moral character guidelines. I've submitted those to the executive director. There are a number of legal nullities in there. I'm happy to provide that to anyone that asks. And last, I guess my biggest concern is that there are items not getting to you and being withheld by staff. I think that occurred during the time that I also worked at the State Bar. But I want someone to address that and ask why they're not being submitted timely and why, at least for me, I've had to go back to the staff a number of times. It's not Kim Wong, your liaison, but I just wanted to let you know.
All right, thank you. Again, thank you to all those who did submit public comment. And moving on to the next item on the agenda, there's a, Amy says a planning session discussion.
Yes. Good morning, everyone. As we do for CBE meetings in January, this next portion is our planning session where we look at what we've achieved the previous year, so in 2020, along with revisiting our goals against a strategic plan to determine what goals we'll be taking on in the coming year. So with that, I'm going to open my PowerPoint to give you a sense of how we came about, on how we took this task on. So give me 1 second and I will share my, oops. Can you see my screen right now?
No.
Okay, give me 1 second.
Take one of photo.
What was that?
I was just curious about, I know we are following the, what's it called? The agenda, but I was curious if we'd be able to amend or add any of the previous discussions of public comments to the agenda so we can address it accordingly.
So under Bagley-Keene, we're required to agendize our discussion items. There are items, for example, related to the bar exam, I think that we're going to be, that we have on the agenda. So that might provide some opportunity. So I'm not sure which ones you're referring to, Michael.
I'm referring to the most recent comments about the spam situation for notification and acceptance, I believe, to partake in the bar exam. I think that's a timely matter that should be discussed sometime this morning when applicable.
Okay, you know what, let's, I'm gonna defer to
Mr. Lawrence.
to our general counsel.
So, hi, Michael. Amy's correct that because that item isn't agendized for discussion, it doesn't provide the public who's not in attendance at the meeting today adequate notice that the committee is going to be discussing and potentially taking action on that issue. But as Amy said, I think if we have an item that addresses the February bar exam, it might be appropriate to discuss various components of the February bar exam, which might include the testing conditions, required document, and so there could be some discussion there. But again, it's not agendized for an action item. So it'll provide an opportunity for the committee to discuss, but not necessarily take action today. But as you know, we can always schedule meetings with appropriate notice as needed. If it was determined that a meeting was needed after this meeting to address something, that's a possibility.
Definitely, and thank you for that. I just wanted to know about more particulars of the Bagley-Keene notice and the potential timelines to address some of the issues brought up.
Okay.
Thank you.
Thank you.
Yeah, and I just want to echo that. I did make this request to add it to the agenda and it was not honored. So I would love for us to discuss this because as we've seen this morning, there are people that are impacted by this decision. And I think it's our duty as bar examiners to ensure that we respond to these issues in a very appropriate time, considering the bar exam is less than a few weeks away. So if there is an agenda item, could you tell me where we can discuss it so we could provide disclosure to the public about when that will be discussed publicly, or if it's a closed session item, I think that's also an opportunity where we could discuss, but I think this is something very mission critical to our organization. So I'm hoping that we get additional clarity on this.
So under the agenda, we have a February 2021 update that Audrey will be providing as to next steps on the bar exam. So I think that's probably the most appropriate agenda item that we could just have this discussion. And when you submitted the request, Kareem, just to be clear, it's not we're trying to ignore your request. The agenda had already been posted. We need to allow 10 business days for that to happen. So unfortunately, we could not add it at that point. Just as
I believe there was some concessions made by the governor when the pandemic was enacted. So if council could review that, I think there is also a possibility to add special items, considering there was some leniency provided to agencies providing oversight. So I don't know those two particular, but I think Caroline might be able to provide assistance with that. And even at its minimum, the subcommittee on examinations could probably discuss this further as well. But I just hope we have discussion today because I think it's very, very important to the business that we do, and kind of what we're all here to do is really oversee the bar exam. So thank you for that response.
Sure. Okay.
Thank you as well. My final slight comment will be, I'd rather have the applicants be studying for the bar exam rather than worrying about some formalities. But thank you for highlighting what needs to be done or what can be done. So thank you for that, Amy and Caroline.
Sure. Okay. So back to the, any other comments? Sorry, before I jump into the planning session. Okay, wonderful. So in preparation for this, I wanted to give everybody a sense of how we took this task on. So we prepared by going back and noting what functions are carried out. Turn off my computer. Can you hear me?
Yes, we can hear.
Okay, great. Sorry, on my end, the screen went black. Sorry about that. So we went in and looked at each of the functional areas and revisited any changes. We also went back to look at Appendix I to ensure that the tasks that remained in the implementation plans were completed. And as you'll see by each functional area, those have been described in here. Also, looking at the State Bar strategic plan as a way of determining what tasks each of these subcommittees could carry on as part and that align with the strategic plan. We also looked at last year's achievements to see if we were able to accomplish those. We're going to report back on those during this session, and perhaps some of these needed to get repackaged, and that's going to be coming up, as well as reviewing requests have been made here, whether it's training topics or areas to research. And so with that, I'm going to open it up. Each of the program managers will be discussing their area. And the first group that we're going to start with is moral character. So let me bring up that PowerPoint right now, and I will let Tara start that presentation. So let me know when you need to move screens, Tara. Advance.
Thank you. Good morning, everybody. So this is obviously for the Moral Character Determinations Unit. Next slide. So the Subcommittee on Moral Character Determinations, as you all know, with the change, you're now overseeing any administrative reviews for applicants who have been given a negative or an adverse determination by staff, as well as overseeing and administering policies related to moral character determinations. So those are the main functions of our subcommittee. Next slide. Thank you. And so last year was quite a busy year for our unit. The Moral Character Working Group completed their work in February 2020. The work came to you all in April of 2020 and then went to the Board of Trustees in May 2020. The information was updated on the State Bar's website on July 31st, 2020, so it's now available for all. As well as one of the final products of the Moral Character Working Group was the law school best practices and talking points, and that was sent out to the law schools in the quarterly newsletter. In addition, Mr. Lane also created the Decisional Law Library as required by Appendix I, and that'll continue to be updated with new Supreme Court cases as they come up. And AIMS, obviously our information management system, it's still a work in progress, but some of our biggest, let's say, efficiency boosters were we were able to automatically account for gaps in applicants' residence or activities. So rather than staff having to manually go in and calculate that, the system now does that for us, as well as we were able to implement an e-signature. And the questionnaires that we send out to employers, to personal references, those are now automatically categorized for us if there's something we need to review. Whereas again, before when we started on this new system, it was a manual process for staff. Okay, next slide. Thank you. So we'll continue to update AIMS and make small changes as we see fit, but nothing that we can see for the foreseeable future that needs to be done. However, as many of you do know, we do outreach to law schools and whatnot. This year we will be doing some joint presentations with the Office of Chief Trial Counsel. And there was discussion of us trying to have a State Bar Day with Office of Chief Trial Counsel and possibly the Lawyers Assistance Program. So those are on the horizon. And next slide. Thank you. And so some of these training topics are ones that have continued just annually. Obviously with the switch to Zoom, there have been some time constraints or whatnot, or other matters where we didn't get the client trust accounting school or ethics school last year. We do want to try to get those in this year, as well as Debbie Muckamal, who was one of the members of the Moral Character Working Group. There was discussion last year for bringing her in as a speaker. So we're going to carry that over. But here I would like to solicit your feedback. So we had the presentation by the Lawyers Assistance Program, and we will be having the part 2 coming up in March. So we're wondering if there are any topics in particular you would like them to address. This group that'll come from lab will actually include the program supervisor, as well as I believe some of the clinicians themselves. So any feedback that you have that you'd like to provide would be very helpful for them to be able to focus their presentation. Okay. And if nobody has anything that they can think of at the moment, if you would be so kind as to email me or Kim and let us know, that way we can ensure that the training is focused on what you'd like, if there's any other ideas as well.
One thing I just want to add is As you recall, I think maybe if not in 2020, in 2019, we had a presentation on domestic violence survivors and some of the dynamics around that. That was a topic that was suggested by a CBE member. So as Tara suggested, I just want to highlight that we've some of these are most of these requests come from this group. So if there's something that you think of, please don't hesitate to share that. All right.
May I ask a question, Amy?
Yes, sure.
A few years ago, we had an excellent presentation, and it was by Justice, somebody help me if you know what I'm talking about, Louise Moore. She's a veteran, and her discussion was about post-traumatic stress syndrome in veterans. That was interesting because, well, number one, I'm a veteran, but I think that it's important that we've got a lot of individuals that are going to law school who are going through the GI Bill, and some of them may have encountered issues as a result of PTSD, because there's a huge percentage of vets that have been in trouble with the law since serving. But perhaps if we may want to consider having her return to give another class if she has any time.
Yes, that's a really good suggestion. So yes, she was a justice that was a
Justice Moore.
Yeah, Justice Moore in the Veterans Court movement. And so yeah, I think it would be very beneficial. We could add that to the agenda. Go ahead, Tara. Sorry.
Thank you, David.
This is Bethany. I also had a comment. So in regards to additional trainings that might be useful, I don't know if this is possible or would be create like a burden on the trial counsel, but it might be helpful to have a review of some historical cases that have gone before the court regarding people that have been denied admission for a variety of reasons. Because frequently when we're, reviewing these appeals, or even for staff as they're doing them, I think that might be helpful to know what the courts have and have not considered conduct that might impact the person's ability to practice law. And I just think that that would be useful information specifically for us reviewing appeals.
That's a good idea. Thank you, Bethany. There's no others, and please feel free always to email myself, David, or Kim if you have any additional ideas later. So as you'll see later, we do have our moral character goals. Again, it's mostly focused around the training for you all. So again, as you think of topics, please feel free to share those. So we did have the presentation on rehabilitation that was conducted by Mr. Lane. We will have the LAP follow-up presentation in March, as well as we will schedule others throughout the year. Next slide, Amy. I think we're on the last one now. And next slide. And so just for the working plan, so focusing on the strategic goal, just improving productivity through the performance accountability, training, and professional development. So it's just continuing to look at the systems, both our processes and the aims itself, to continue to try to update them to make the process as best as possible. So thank you.
Thank you, Tara. So with that, we're going to move into educational standards. And with that, we have Natalie, who will be leading this discussion. Let me just get your PowerPoint up and running. There we are. Oops.
Okay. Okay, perfect. Thank you. So here we'll be talking about the educational standards section. I'm Natalie Leonard, and if we could advance the next slide, we'll talk a little bit about what we're planning for schools this year. For the benefit of our new member, just reminding that in California, if we slip back to the map, we have a number of unique pathways to law for students. In addition to ABA-approved schools that you find throughout the country, California also has some unique options: a law office study program, as well as an unaccredited law school program, an entry point for a new law school, and a CBE accredited law school program. You can see 16 unaccredited schools, 18 accredited schools in the state. And these schools are primarily designed for people that wish to become licensed in the state of California. And that's where this committee spends most of its time making decisions. Let's move on to the next slide. These three types of schools, the Law Office Study Program is managed through the Eligibility Department. Students can actually, they can intern under an attorney or a judge under specified circumstances over a 4-year period, and that's handled administratively through the Eligibility Department. And then here, the committee works with the other types of schools, whether they are State Bar accredited or State Bar unaccredited. The main difference between those types of schools is that the unaccredited schools are a point of entry. They have a minimal threshold level of requirements. An accredited school has more standards to uphold, including a minimum 5-year cumulative bar pass rate of 40% or more, as well as expanded clinical options and library materials. Next slide, please. Another function of educational standards is law school and at times law student engagement as well. We work throughout the year with the Law School Council, a 7-member council created with deans of law schools or administrators such as deans of students or academic bar preparation individuals. We also work with the Committee on State Bar accredited and registered schools. Includes 3 deans of accredited schools, 2 deans of registered unaccredited schools, and 2 CBE designees. Right now, your designees are Paul Kramer, the chair of your Ed Standards Committee, as well as Greg Murphy, an accreditation expert who has served on state bar task forces, as well as the ABA's council on the section of legal education. We also have a law school dean's e-newsletter now distributed also to registrars, and that will be going out next week, goes out on a quarterly basis. We conduct ad hoc meetings with law school deans and students. We had several of those this spring and summer, getting ready for the online bar exam and online first-year exams as they launched. We have an annual meeting for registrars and also an annual law school assembly, primarily for deans and other academic administrators. Those were held for the first time online in December. Next slide, please. Throughout the year, the committee is involved with educational standards in a number of ways. You may be registering or accrediting qualifying law schools. Last year, 3 schools were accredited, 2 schools transitioned from ABA status to accredited status. 2 schools also transitioned to registered unaccredited status. You're also monitoring law school compliance throughout the year in terms of different motions for changes that the schools may file, or conducting, participating on review and inspection panels, or reviewing those reports here in the committee. You're also fostering active law school engagement by your participation in these various meetings and partnering with the Access and Inclusion Office to promote access to justice. Next slide. In 2021, we anticipate another busy year as we had last year. You have been working on a new set of accredited law school rules. They are being posted for public comment right now through February 15th. They'll return to the Board of Trustees to be considered at their March 18th meeting. In addition, you will also be looking at whether to extend the COVID emergency rate waiver that you put in place back first in March and then later extended in June that allowed the fixed facility programs to teach online. This body was one of the first to make a full year waiver. And as time went on, it turns out that many people followed your lead and was able to help our students who are often non-traditional or mid-career students to make long-range plans and to be able to stay in school this year through the committee's quick action. You'll also continue to collaborate with Access and Inclusion. There is a second year study looking at diversity and retention initiatives that are in place in law schools today and thinking about how the State Bar can help with additional programs that might come about in the future. You're also through a request from Kareem Gongora on this body, looking at whether or how the State Bar can help to communicate the types of teaching modalities that accredited law schools offer. They have additional flexibility and additional combinations in teaching, and we're thinking about how to communicate that to the public. And you may be pursuing mandatory accreditation, a path to continuous improvement for the registered schools. Next slide, please. In terms of training topics, we've been talking a lot about how COVID may have impacted the schools. In addition, how the new rules should be formulated and how they will impact law school operation. We think that that might be a rich continued training topic discussion. And maybe also looking at the changes that have come about and the advances that have come about in online education and the impact of the pandemic. I'd be interested to know if there are other topic or training ideas that you would be interested to see. At one point, the group talked about looking at education from the point of view of someone who's grown up in a digital age. And at this point, we are all in the digital age. But I wonder if there are other topics that people would like to suggest.
Hi, Natalie, it's Kareem. Thank you for that presentation. Always thorough, always down to the detail. I wanted to maybe potentially have I believe it was a diversity, equity, and inclusion clause that we included into the new rules, but there's a office that we have, and I can't remember the name off the top of my head, but if they could do a presentation on how of their work or what's being implemented from their office, I think that'd be helpful for us to kind of understand all the moving components. Because I remember I've been here, I believe in February will be 2 years, which is crazy. Considering pandemic time, I feel like I've been here for 10 years. But I think that there were so many activities that the bar was doing, great strides. I just don't know where they're all at. And I think there was like three surveys we did and things of the sort. So that'd be cool to get a wraparound of where everything's moving and what the progress is.
Sure, that would be, I'd be happy to do that. And in addition, at the CS Bar's next meeting that's coming up in March, on the Wednesday before the committee's meeting, there will be representatives from the Office of Access and Inclusion and perhaps also the Council on Access and Fairness coming to work with CS Bars, actually to look at guidelines for that section, the diversity, equity, inclusion section of the rules. So I'll be sure to send out a reminder when that's approaching in addition. Mm-hmm.
Thank you so much.
Sure, thanks, Kareem. Any others? Okay, let's go on to the next slide. So when we're thinking about 2021 current goals, number one, of course, would be to continue to advance the rules proposal that has many excellent updates, including best practices and the creation of a jointly accredited status, as well as the diversity, equity, and inclusion section that really is pretty groundbreaking here in California, and we're excited to get that going. You'll continue to register, accredit, and monitor schools. We expect that at least 7 schools will be inspected this year. You'll be reviewing changes as requested. And you'll also be able to look for the first time at the new expanded demographic data that was collected through the annual reports received in November. And we've been working on cleaning that data, getting ready to show you later this spring. We will, as Kareem requested, continue to work with Access and Inclusion, continue to support law school efforts, pursue mandatory accreditation where we can, and help to facilitate the State Bar Day that Tara mentioned recently. Next slide. In terms of Appendix I, a number of things had been complete previously. The main thing that we are still working on is advancing the rules proposal. We're at a very advanced stage in that. We're very close to bringing something back that can be implemented later this year. And the other elements had been complete previously. Accrediting online JD programs. We now have 5 such JD programs. Starting the Committee on State Bar Accredited and Registered Schools. Reformulating and focusing the Law School Council to focus on ABA-approved school concerns. Enhancing the Law School Assembly, sort of the way Kareem was talking about, to really create a two-way dialogue between the schools to not only tell them what the State Bar has been working on, but also to get the feedback from the schools to enhance what we're doing. And the quarterly e-newsletter has been an excellent source of information for the deans, now expanded to the registrars. Next slide. So we'll just very quickly go through, I mentioned most of these initiatives, but the work of this committee relates to the overall strategic goals of the organization in terms of becoming more transparent, accountable, and efficient through an updated set of rules that truly focus on the key purposes for accreditation. Studying improved approaches to increasing access to justice through a partnering with the ANI department, but also with updating the rules to reflect these values. Working with the California accredited schools to develop enhanced demographic reporting to understand retention of all law students in general, diverse law students in particular. Goal 4, identify means of supporting existing law school programs to improve retention. Those two elements are really wrapped together. And then finally, assuming positive results from the productive mindset, bar strategies, and stories, if that is rolled out on a wider basis, we'll be working with the students, the graduates, and the schools to help engage them in that rollout. Next slide. So I've talked about these groups previously, so we'll just go through them very quickly. CS Bars and Law School Council work plans, really those groups are there to provide feedback, support, and a means of research for this body. So CS Bars will be working on those same initiatives that we described above. There as a resource for you. You can go to the next slide. And their goals, not surprisingly, will be there as a resource for you directly, but also they help us operationally inside at the State Bar. For example, giving insight as to the wording when something comes up or is coming up in the applicant portal. We've been able to make some good changes based on those suggestions. Next slide. Not surprisingly, their work plan aligns with the same goals of the educational standards work in the same format because they're here to support you. And similarly, when we go to the next slide, we'll see that for the Law School Council as well. The Law School Council meets just twice per year. They'll be meeting again just before the committee's April meeting on that Wednesday prior, again, providing this type of feedback for you. Next slide. And similarly, their goals will match with your goals. Next slide, please. And their work plan will match with your work plan. Next slide. So this is just a recap of some of the stats. I won't read them in detail, but you can take a quick skim. You've had a very busy year. You've made a terrific impact on the schools this year. You've been able to support schools through a number of changes, not only the pandemic waiver, but also significant improvement in their compliance. And we think as a result in the education that they can offer to students. You've also helped the LAP to adjust its offerings to respond to students in the pandemic. And I thank you for this work and for the impact it's made on access to justice in California. Any questions? Okay, thank you. I'm here at any time for questions, along with Ashley Kane, who helps us in the office as well.
Thank you, Natalie. Okay, so our next presentation, let me pull it up, is from Tammy on O&M.
Good morning, everyone. As soon as Amy gets that up, I'll go ahead and start. So as many of you know, operations and management, our main focus is making sure that everything revolving around the bar exam is able to be accomplished, including finding applicants eligible to sit for the exam, as well as processing all applications and collecting and refunding all payments. Just some of the high overview functions of operations and management is the reviewing issues related to the administration of examinations and consider applicants' petitions for waivers to committee policies and rules. We also review and prepare reports with a summary of the administration for each first-year law students examination, as well as the California bar examination. And we also conduct Chapter 6 administrative hearings upon request for applicants who have been imposed a disputable sanction. Next slide, please. Some of the changes that were implemented in 2020 was continued enhancements of AIMS. We made improvements to the interface between AIMS and attorney regulation, so that way we could accurately display information on the attorney search tool and licensee billing for the multi-jurisdictional program, or what we refer to as MJP. We adjusted and implemented automation across several different tasks within the AIMS system, such as automated emails, certification process to approve applications in bulk, among other areas. We also revised programming for the practical training of law students application to accommodate so that they could list multiple supervising attorneys and then process those online payments for each of those all in one area. Next, okay. Under the procedural and policy side of it, we did, due to COVID-19, which was a very big year in O&M regarding to revolving around COVID-19, we adjusted policies to accept electronic certificates of good standings from jurisdictions who were unable to issue original documents to us. By direction of the Supreme Court, we updated the Business and Professions Code and admissions rules and guidelines so that we could accommodate for applicants taking the June 2020 first-year law students examination an extra attempt at passing this exam due to the pandemic. This also included some modifications to AIMS. We also transferred the Chapter 6 administrative hearings process to be completed by admissions staff, with CBE serving as the appeal body, which was part of the Appendix I initiative. Again, due to COVID-19, we changed the modality of the first-year law students examination and California bar examination from an in-person to an online remote exam. And we also implemented the provisional licensing program to allow applicants that graduated starting in December 2019 to practice under the supervision of an attorney through June 2nd of 2022. And I believe that's June 1st, sorry. And then again, under procedural and policy, we had the expansion of the provisional licensing program to include the individuals who scored 1390 or higher. Oh, sorry, this is changes anticipated in 2021. We moved over. And for those who scored 1390 or higher on a California bar examination administered between July 15 and February 2020, they will be allowed to participate as well in the program through June 1st of 2022. And the other area is we are planning to review the interpretation of admission rules, such as the area of eligibility and administration of examinations. Next slide. And then other changes are the continuation of working on the production for various admissions training videos on the following topics, such as online video on how to prepare to take the bar exam for applicants, as well as proctor training videos to help them understand what will be expected during an exam. Of course, with the change from what we normally do in person to an online exam, this has caused a little bit of a delay for us to do this, but I think once we get to a better place on how we're administering the exam moving forward past the pandemic, we'll be able to get these videos going in the right way. So some of the current goals that we have on the agenda is we have seeking the waivers of the committee's administrative related policies, procedures, and rules. We do that at each meeting if there are any appeals at that point to put forth. We review reports on the administration of the California bar exam. We do that after each exam. For example, this year, it will be this month's meeting as well as approximately around March of 21. We will also, we had the review of the report on the financial impact of the modified 2-day California bar exam. And that was actually presented to the Committee of Bar Examiners last month at the December 2020 meeting. So that has now been completed. Next slide, please. We will also be reviewing the reports on the administration of the first year law students exam, which will be approximately March of 21 as well as August of this year. We will also work on trying to complete the production of the admissions training videos. It was slated for winter of 2020 and 2021. However, that is going to be pushed back based on where we are with administering the exam right now. And we're also going to work on those proposed guidelines for interpretation of the admission rules. And again, that was set for winter 2020, 2021. However, again, with everything that was been going on with the exam changed in modality, we will be focusing on that a little later in this year. So that's everything under that area for now. I would like to open this up to see if there's any further suggestions of something that we would maybe want to put on for current goals to look at in the future. And so I'm not hearing any suggestions. So if any of you would want to bring something up after the meeting, of course, you can always reach out to me as well as Kim Wong and let us know if there's something you would like to add, and we can look at it further from there.
Sorry, I don't mean to interrupt you, Tammy. I just have one item that I want to flag here. At our last meeting, Kareem Gongora brought up the idea of revisiting kind of the fee process for applicants to the bar exam, perhaps looking at like a structured payment process. So I want to like jog everybody's memory, and perhaps this would be the most appropriate spot to put this. It's under O&M as a goal for 2021, perhaps. But I don't want to. I'm just trying to remember. I'm sorry. I'm just trying to remind everybody about that discussion so we just don't lose sight of that. I'm not sure if there's still an interest in doing that.
Yeah, Amy, this is Paul. I have a related question. There was a time in the recent past where I had cause to look at the schedule of fees, and it appeared to me that the fee for the attorney's exam was higher than the fee for the general applicant's exam, and that didn't make sense to me since it was shorter. So I'd love to maybe just have a review of how the fees are set and the cost basis for them at some point.
Okay.
Okay, I've got that noted. Anything else that wants to be brought up at this point? Okay, so we'll go ahead and move on to the next slide. So for our recommended work plan, the item that we have right now is the report that was provided to the CBE in December on the financial aspects of moving from the 3-day to the 2-day exam. We will now be moving forward with that being presented to the Board of Trustees at the next meeting in March of 2021. And at this point, this would be the only goals we have for the work plan for this year, although I am sure there will be some that will pop up throughout the year, and we can add to that accordingly as we go. Next slide, please. And that's it. That is my last slide. So does anybody have any other questions or anything that they would like to address for O&M right now? Okay. All right. Well, thank you, everybody. And back to Amy.
Yes. Thank you, Tammy. All right. Our last presentations is going to be on the Subcommittee on Examinations. We have Lisa, who will be presenting, and let me pull up those slides now. All right, Lisa. Sorry, this is a combination of Lisa and Christina. Sorry about that. Do we have Lisa and Christina on? Oh, Lisa, you're on mute. Oh no, you're not on mute, but we can't hear you.
I'm on 100%.
Oh, there you go. We can hear you now.
Sorry.
No problem.
With my speaker lately. Yeah, so I will be presenting on the examinations, and I'll have Christina jump in at any time that she wants to add something. So I am the program manager for examinations. Christina oversees the examination grading. Next slide, please. So the subcommittee on examinations has some primary functions, and those are listed for you on the slide right now. So for the bar exam, the subcommittee oversees the format, the scope, the topics, the content, and the grading process. The committee did used to have some oversight of the cut score, the passing score. However, that was transferred to the Supreme Court. And then for the first year law students exam, you have the same functions, but you do also determine the passing score for that exam. The subcommittee also does oversee the EDGE team and the grading process with regard to the exams that the Office of Admissions administers. We also consider petitions seeking waivers of the committee's exam-related policies, procedures, and rules, including appeals regarding staff denials of requests for reconsideration of examination results. Also, the subcommittee has primary responsibility for reviewing the psychometric and bar exam reports. We also, you also consider appeals of staff decisions that are filed by applicants with disabilities requesting testing accommodations for taking the examinations. Next slide, please. So the changes implemented in 2020 for exam development. We did limit the question selection process for the bar exam to the attorney members of the committee pursuant to B&P Code Section 6046.5. We did also develop the first time ever format for the online California bar examination so that it was compatible with and addressed exam security and integrity concerns of a remotely proctored exam. Did the same for the first year law students exam. Next slide, please. So changes implemented to grading in 2020. And Christina, please jump in if I miss something or you want to add something at this point. So the Supreme Court and the Committee of Bar Examiners did mandate changes to the bar exam resulting from the Appendix I review as well as the situations relating to the COVID-19 pandemic. And those were the elimination of the third phase of grading. The bar exam traditionally had 3 phases of grading. Now there are 2. And then there was a shrinking of the reread band. So after first read, there's second read, and there's a certain score band that examinees who have scores within that score band do automatically go to a second read. We did increase the number of graders for the October exam. That is something that the committee did authorize us to do when needed. If the circumstances needed more graders to carry on the workload, then we were authorized to do that. And the big thing was that there was a lowering of the pass score as mandated by the Supreme Court from 1440 to 1390, which is a 50-point decrease. So we also transitioned the grading calibration sessions from in-person, which they were traditionally held, to virtual meetings to adapt to the pandemic conditions. Also, we implemented more in-depth real-time monitoring and tracking of grader performance through the exam cycle through more statistical reports that were provided to us by the committee's psychometrician. Also, we worked hard to decrease the wait time for results and the dissemination of essay answer files. So after the release of results, the applicants are provided with their actual answers, and we have reduced the time that we're releasing those files. Also, the staff, the graders, and the EDGE team being the examination development and grading team, were trained on the new processes, which include implicit bias training. Internal protocols, checks, and balances were also developed to deal with these changes. Next slide, please. So the changes anticipated in 2021 in both examination development and grading. One is to develop the development and delivery of some enhanced training for the new and existing EDGE team members. Development of new subject matter matrices, which we hope to post on the State Bar's website. The identification and implementation of ways in which diversity and inclusion principles can be institutionalized into the bar exam development processes. An improvement of the State Bar's collaboration website to enhance the secure electronic receipt and review of the questions by the EDGE team, and more efficient monitoring of the tracking of the question drafts. Next slide, please. Training topics for 2021 in examination grading primarily. So the development of policies and procedures and guidelines for exam reconsideration requests, both from test center incidents, so incidents that happen at the test center. Oftentimes we get requests from applicants to reconsider their results based on those, as well as examination results. So if there's reconsideration policy based on if there is a mathematical error that is found, or a clerical error, as well as one more error area. And then presentation on principles of scaling, hopefully from our psychometrician or some other subject matter expert. We are hoping to present to the committee in 2021, as well as a presentation on the phase grading system for the California bar exam, which has, again, as noted, changed recently. And I'm open now for any other suggestions that anyone may have with regard to exam development or examination grading, some things you'd like to see. Okay, so again, as with everybody else has been saying, feel free to contact me if you have anything that comes up that you haven't thought about at this point, and always happy to listen to your suggestions. There's the next slide.
Oops, sorry. I thought I was done. Sorry about that. Let me get to it. I need 1 second.
Okay, so current goals. These are in a just sort of an overview. There are a few more goals related to your regular work that you do, and that those will be presented in the open session a little bit when we finish the planning session. So for examination development, current goals include monitoring the work of the California's Blue Ribbon Commission on the future of the California bar exam. The committee has, the Supreme Court will be making those appointments soon, I believe. And then also monitoring the work of the National Conference of Bar Examiners, the NCBE testing task force, doing parallel work on the next generation of the bar exam. Also considering the CAPA study, which is the California Attorney Practice Analysis Study, which has already been done, but considering the impact that the findings from there and the recommendations from there have on bar exam development, and those will sort of go hand in hand with respect to what the other groups are doing. And then also consider additional studies to be done post-CAPA, for example, a new content validation study. And the last one, I believe, was done in 2017. For examination grading, to consider any additional proposals on ways to reduce the time it takes to release the results from the California bar examination. And then for both examination development and examination grading, working with the State Bar's Office of Access and Inclusion and COAP, which is the Office of Access and Fairness, to develop processes and procedures in exam development and exam grading that advance the mission of the State Bar to support efforts for greater access to and inclusion in the legal system. Next slide, please. Okay, so last slide, and you'll see that this dovetails into what I just mentioned, but we did objective O, goal 2, which was to consider the report prepared by the State Bar's Office of Finance on the financial and budgetary impacts of the transition of the modified, which was going from the 3-day to the 2-day California bar examination, was already done. It was done in October of 2020, your last meeting. And then the one that we have will be focusing on for 2021 is, again, to work with the State Bar's Office of Access Inclusion and Council on Access and Fairness to develop processes and procedures in exam development and exam grading that support that greater access to and inclusion in the legal system. And that is an ongoing thing that we're working on. Okay, that's it. Thank you.
Thank you, Lisa. All right, so we paused between each of these areas to see if there's any suggestions on training topics or ideas. We've not received any, which is not a problem. If any come to mind at a later time, please don't hesitate to share those with us. We are a little early, and I want to bring this back to our chair or co-chair.
Amy?
Yes, Paul.
Regarding exams, Lisa and I had talked about bringing back that consultant we had about testing accommodation appeals. Was that still on the list, Lisa?
A consultant, are you talking about Dr. Levitt, or he presented on substantive matters, or?
Yeah, I think that he was the most recent one, I believe, yeah. Correct?
Correct.
Yeah, I think everybody really was impressed by him, and if we could think of ways to lever his expertise some more, I think we thought it would be useful.
Okay. Well, I can work with Jim and Vince, and then whatever input anybody else wants to put, including you, Paul, in terms of developing some kind of training or some kind of presentation for Dr. Levitt to do. Sure.
Okay, thanks.
Great. Any other suggestions or thoughts, responses? All right. Well, back to you, Alex. Thank you.
Great. Thanks, Amy. Thanks for all the presentations. I have only 3 more items under the chair's time, and after that, I would like to take a 10-minute break. I think everybody would or possibly appreciate that before we return back to you, Amy, for a director's report. So the next item on our agenda is recognition of outgoing member. As many of you know in the committee are aware, in early December, Dr. Ikatep retired from the committee to supplement the workforce in addressing the challenges of the pandemic. I know I can personally say for myself, I enjoyed working with Dr. Ikatep on this committee, and appreciate all her feedback and comments and participation in things as it relates to visiting schools and test sites and more. There's a recommendation to acknowledge Dr. Ikatep's service, but before we move on to the proposal or motion is reviewed, would like to see if there's anyone who would like to make any comments.
I would love to. This is Kareem, Mr. Chair, if I'm able to. I echoed this in the last meeting, but I have to repeat it. Dr. Ikatep is amazing, phenomenal. I mean, the oath she took as a healthcare professional translated into her work as a bar examiner, and it's a big loss to the committee. I wish her the best. She was a really influential and very inspirational individual in my life during the time she's been on, and so I have nothing but the utmost respect, and I wish she would reconsider, but I know we're in some challenging times right now with the pandemic and in her role that she provides as a healthcare leader, right? And so I just have to say on record, she is amazing. She's phenomenal. And I'm going to miss her, and I know we all will. So those are my comments.
Thank you, Kareem. Are there any other comments?
Mr. Chair, this is Ravi. I'll just echo Kareem's comments and say I talked to Angela yesterday. She is very remorseful and is much missing working with us and involvement with our group. You know, she's actively practicing medicine again. She was called in, you know, to assist with work with the pandemic, and that really is taken priority for her. And I applaud her devotion to that. And she misses us much, and she deserves our recognition today. So thank you, Alex.
Thanks, Robbie, for your comments.
I also want to convey Dr. Agatep's message. Basically, she said that thank you to the committee for the time that she spent with all of you, and she appreciate that.
So there is a recommendation to acknowledge the service of Dr. Agatep and direct a certificate prepared and presented to her, as well as a proposed motion. Would anyone like to make a motion?
I'll make that motion. This is Robbie Brody.
Kareem will make the second.
Great. And just for recording purposes, I would like that each member's vote be recorded by Ms. Wong, and not just for this item, but for all three that we're going to be addressing here in a second. So Ms. Wong, do you mind taking the vote?
Sure. Dr. Bolton? Dr. Bolton? Judge Brody?
Yes.
Dr. Kao?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman? Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Ms. Pick? Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres?
Yes.
Dr. Wilkinson?
Yes.
And then Vice Chair, Mr.
Yes.
Lawrence? The motion passes.
Thank you. The next item on our agenda is the approval of the October 16, 2020 Committee of Bar Examiners amended public meeting minutes. Again, you do have a copy of that, but just real briefly, it was moved and seconded and duly carried that the updated rules proposal to replace the accredited law school rules, incorporating the changes submitted by committee members Paul Kramer and Michael Kao, be noted and recommended to the Board of Trustees for circulation for public comment and further consideration for approval with the request that the trustees route the public comments back to the Committee of Bar Examiners to allow it to review the comments and offer any additional recommendations. Again, you do have a copy. Don't know if anybody or would open it up if anybody would like to make any comments or have any questions.
I will make the motion to approve, Mr. Lawrence. It's Robbie Brody.
I'll second Dolores.
Great. Thank you. Ms. Wong, will you please take roll.
Dr. Bolton? Judge Brody?
Yes.
Dr. Kao?
Yes.
Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman? Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Vice Chair, Mr. Lawrence?
Yes.
Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Judge Toriaba?
Yes.
Mr. Torres?
Yes.
Dr. Wilkinson?
I'll abstain. I wasn't in attendance at that time.
Thank you. The motion passes.
Thank you. And the next item on the agenda is approval of the December 4th, 2020 Committee of Bar Examiners public meeting minutes. Again, you have a copy of that. Are there any comments?
Move to approve.
Is there a second?
Mr. Torres's motion to approve. This is Robbie Brody.
Okay. I'm going to take roll call. Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Chair, Mr. Lawrence,
Yes.
Ms. Pig,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
Mr. Torres,
Yes.
Dr. Wilkerson,
I'll abstain.
the motion passes.
Thank you. So let's take a 10-minute break. It's a little after 10:35, so return about 10:45. And then we'll have a report from the director as well as try to get through as many agenda items before lunch at 12. So again, see you back here in 10 minutes. Thank you. I love it. People are coming back. This is fantastic. We'll give it another minute or so. I know it wasn't as long of a break that many may have wanted, but we have a lot of items to get through.
Am I muted?
Not anymore. We can hear you.
You can hear me?
Yes, we can.
Okay.
Okay, I see people popping in back in the committee, and there's probably a few just maybe their videos are muted, but Ms. Wong, do you mind doing a roll call, please?
Sure. Dr. Bolton,
Here.
Judge Brody, Dr. Cow,
Here.
Mr. Chen, Mr. Efting,
Present.
Mr. Gongora,
Present.
Ms. Heisinger,
Here.
Mr. Iseri,
Here.
Mr. Kaplan,
Here.
Mr. Kramer,
Here.
Ms. Pick,
Present.
Mr. Reyes,
Here.
Judge Toriaba,
Here.
Mr. Torres,
Here.
and then Dr. Wilkinson. We have a quorum.
And Kim, I'm here. It's Robbie Brody.
I
Sorry.
saw you. Thank you, Judge Brody.
Great, thank you,
And
Ms.
Berger.
Wong. So now I'd like to turn it over to Amy for the report from the director.
All right, good morning, everyone. The first item under my section is the report on the key statistical indicators. This is a standing agenda item, and what I do for each of these meetings is highlight any application with a 15% change when compared to the last when compared to last year. So for this year, I think the glaring item is the number of applicants that have been placed on the motion. When you compare 2019 and 2020, it looks like we had a 49.3% decrease in the number of people that were placed on the motion. And this is primarily due to the fact that the July 2020 California bar exam, the rescheduling to October, meant that results weren't released until 2021. So it does not mean that it really led to less applicants being licensed in 2020. It did, but it's not as a result of the bar exam. So I just want to highlight that. In terms of the registrations that were received, we had 14% more attorney applications this year compared to last. As for the attorney examinations themselves, these are attorney applications for the bar exam. We had 17% more in 2020 when compared to 2019. As for the other areas, MJP applications, we had 80.6% more in 2020 compared to 2019. As well as Pro Hoc Vice, 28% more in 2020 compared to last year. And I think this is very interesting, and I think Natalie touched upon this earlier. It's been a very busy year for the committee. When we evaluate the number of petitions reviewed by the committee, the first category, petitions that are, these tend to be either from operations and management or examinations. They do not include moral, character, TA related. We had 67% more that were reviewed by the committee in 2020 compared to the year before. As for TA petitions, the same thing. The committee reviewed 18% more this year or 2020 compared to 2019. And lastly, in terms of law school reports, the committee reviewed 58% more reports in 2020 compared to 2019. So it's been a very active year for this committee and for our staff. Any questions related to the key statistical indicators? All right. Then our next item is a review of the schedule for our next CBE meeting, which is set for March 26 and 27. It's scheduled as a 2-day meeting. And it is, posted as attachment 104. Any questions related to that? Okay. Now, the next item are various updates from initiatives that are happening in the Office of Admissions and State Bar wide. And we have corresponding CBE members for some of these so that they can provide that update. And the first is the Provisional Licensure Program. And with that, I'm going to hand it over to Paul Kramer and to Dolores Heisinger.
Okay, thanks, Amy. It's really over at this point. You've heard in the public comments. We'll likely talk about it a little bit later. But the Supreme Court yesterday approved proposed rule changes that permit bar takers who scored 1390 or above, but not enough to pass between the July 2015 exam and the February 2020 exam to participate in the PLL program. And after they complete 300, which was a reduction from the number of hours that the working group recommended, after they complete 300 hours of supervised practice, then assuming they meet all the other requirements to become a licensed member of the bar, they will be able to become licensed without having to retake the bar exam. So that's, they have asked that the staff and the bar make entry of those folks into the program available by March 1st. So it's not running yet, but it's been enabled, and I assume staff will be able to meet that deadline. Dolores, did you want to say anything else?
Dolores, I think you're muted.
No, I just wanted to add that, just to remind everybody that this program came about as a result of the challenges of the COVID vaccine on law students. And so I think this will end up being one of the more monumental changes in general made by the State Bar and the Supreme Court in many, many years. So it's, you know, it's something that we should continue to be aware of, because it's going to have, I think, repercussions for many years to come. I think both good and maybe some problems.
It will sunset unless it's extended at the end, or rather, I think it's the end of June in 2022. So it won't go on forever. But you never know. If the virus continues to make taking the exam more difficult, they may extend it for a time.
Okay. Well, thank you, Paul.
I have a quick comment, if I may. What it have we? I know. So I don't know if it's not really exclusive to the program, but the Supreme Court also did apply the 1390 retroactive. So I don't know if this is the space to discuss it or if it's for a later discussion, but is there a moment where what that'll be evaluated and how that impacts? Basically, that really revolutionizes a lot of the work that's being done.
Well, Kareem, I think it's not precisely correct to say that they applied the cut score retroactively, because they've kind of gone out of their way not to say that, for one thing. What they have done is made it possible for people within the time window of the bar exams that are affected, but also within the time window of the program, to be able to take their 1390, and after they spend the time on supervised practice, to become a member of the bar. But if they don't complete that by that June 1st or 30th, I forget the exact date of next year, then their ability to skip the bar exam, or in effect have it retroactively, the lower cut score applied, will expire.
Okay, I appreciate you saying that because I didn't know that, and that's a very key fact. When I read the order, I was confused on that particular part. So thank you for that, Paul.
Sure.
Okay. Any other comments related to provisional licensing? Okay, so we'll move on to the Blue Ribbon Commission. The State Board of Trustees, or State Bar Board of Trustees, approved the establishment of a joint Blue Ribbon Commission on the future of the California Bar Exam in partnership with the California Supreme Court. And that commission, again, just to remind everybody, will be reviewing findings from various bar exam studies, such as CAPA and the NCBE job analysis, to determine the future of the bar exam format and its scope. The Supreme Court will be selecting members next month in February, at their February meeting, and work will commence soon after that. As soon as we are informed of who's been selected for that committee, we will make that announcement. All right, any questions, thoughts related to the Blue Ribbon Commission? Okay. All right, so then with that, we will move to our next topic, which is the February 2021 California Bar Examination.
Hi, good
And
morning. Oh, sorry.
sorry, and we have Audrey who will be presenting on that.
Good morning, everyone. It's me, Audrey Ching. So we're about a little over 3 weeks away from the February bar exam. So I'm here to give you some updates. So as of this morning, we have 3,804 approved applicants, 438 pending for the exam. This Monday, January 25th, was the final filing deadline for immediate repeaters. The following day, the 26th, we sent out the admittance tickets, and we also opened the mock exams. So applicants are required to complete at least 2 of the required mock exams. They're also optional mock exams for them to practice. They need to complete these by February 12th. I'm mentioning this because we are going to talk about important deadlines. February 12th is an important deadline because if applicants do not complete the 2 required mock exams, they will be deactivated in the ExamSoft system, unable to sit the exam, and then withdrawn. So just want to put that out there since we are talking about important deadlines today. And then applicants will have between February 17th and February 22nd to download the answer files. Obviously, February 23rd is exam day. Those were the major updates I was going to give everyone about the applicant pool and where we are with deadlines. I know we also want to have some discussion now about what was talked about in public comment. I don't know if it might be helpful before we take discussion, but I can kind of talk to you about what I understand from our IT department about the way that we use Salesforce, which is it's a CRM, and we use it in our communication. It's our database in the way that we intake all the information for all our programs and admissions and the way that we communicate with applicants. So I know that there's been some conversation about us using a third-party vendor, and Salesforce is our database. So that is what we use to communicate with applicants. We have a variety of email accounts by our different areas in admissions. We have a general email account, admissions at calbar.ca.gov. We have an eligibility email address. We have a testing accommodations email address, moral character. And then before the June baby bar, because it was our first online exam, we also set up a new email address, online_exam. And that's one that we've been using to make sure we're routing appropriately email communication about the remote exam. That is the email address that we use, online_exam at calbar.ca.gov. And that's the address, if you whitelist all our calbar.ca.gov emails, it will go to your inbox. There is, depending on your email filter, you can see an entire like via routing address. And I think maybe that's what was referenced. So you can see from any of our email addresses that things are routed to applicants via Salesforce. But the email address itself is a calbar.ca.gov address. And if you whitelist our email communication, then you will receive all of our communication from admissions. What else might be helpful? We put, based on, we had a lot of feedback from the October exam in a lot of different areas. And we've talked about a lot in this meeting. In all the December meetings that we had this meeting, and we had meetings of CS bars, law school assembly, registrar's meeting, law school council. We talked all about the important deadlines related to the February bar exam and whitelisting emails from admissions. We also made sure that the deadlines that we posted for the February bar exam were not just statutory deadlines about final filing, but also all of these deadlines related to the remote exam itself. So that was posted and made live on October 10th, our important deadlines page that included this January 15th date about returning your testing conditions form. So we made sure that that feedback from applicants about making sure all the important deadlines are posted. Also, the deadlines posted on that webpage include everything I just mentioned about our mock exams and about ExamSoft. So all the deadlines that are really important for applicants to know, we posted October 10th, so several months in advance, obviously, of the exam. What else might be helpful before a discussion?
I think, Audrey, sharing some of the things you talked about are initiatives or measures that we put in place for this next exam from what we gathered in our experience with the October 2020 exam. And so we also instituted reminder emails. So aside from alerting people to whitelist our email address, which would have addressed a lot of these issues. Can you talk about the number of reminder emails and then also our weekly email reminders?
Yes, thank you. So we started sending out to applicants on December 3rd, the initial email with their customized link. So this is why it's an email. It has a customized link. The applicant has to sign and accept under penalty of perjury these conditions. So it's a customized link because it's custom to that applicant and their file number. So this is why we send these emails with these customized links. So we started sending this out on December 3rd, and then we sent out reminders December 17th, December 5th, December 31st, January 7th, January 10th, January 14th, and then our communications department works with us to start sending out Friday email communications to applicants. We started those on January 15th. That January 15th email said it's due today, 11:59 today, the testing conditions. So there were a variety of emails. Also, to be responsive to applicants' feedback from October, we also sent emails letting them know when it's been submitted, because I know that was something that was a missing piece, that now we have an email that goes out, it's been submitted, so people know that they've submitted their form back to us with an email.
And so we talked about the reminders, we talked about the whitelisting, trying to get that information onto our FAQs.
Oh yes, yeah.
And then, so with that,
we posted a PDF of the testing conditions to the FAQ, so everyone knew, just in case they weren't able to save it on their end, what they were agreeing to, and then let them know again in the FAQs that they needed to accept their customized link to be able to submit the form.
And I think it'd be helpful to understand why that we need the testing conditions. What does a testing condition, what actions are sprout from that document itself? Because I think the concern, what's out there is that it's an arbitrary date that could be easily moved. And Audrey, I think it'd be good for the committee to know, what does the testing condition, what activities does it activate?
Yeah, so just in case you haven't been to the FAQs and looked at the document yourself. So the testing conditions document is not just about the remote exam and accepting the testing conditions that are unique to that exam. Applicants can also on that form request to handwrite the exam, or they can let us know that they have extenuating circumstances where they live in a home with multiple roommates or multiple children, and they want a quiet place to test or reliable Wi-Fi. So they can let us know that they need our assistance at the bar to find a place to test. And so that affects our in-person numbers. Obviously, everyone can remember from October that we kept our 6 hotel sites that are our typical testing accommodation sites. And we also opened them up to individuals who requested a handwrite or had extenuating circumstances. But since those are hotel contracts that we need to do in advance and try to peg to a number of folks that are coming, also with all of our COVID concerns about how many people are coming to each of our sites, it's really important because we have to review each of those forms that come in, read through the statements from applicants, understand why they might need a handwrite, understand why they might need to come to one of our testing sites to come in person. Those are all things that take time, and it's not arbitrary to us. We work backward from the exam date and the contracts that we need to have with these hotels to make sure that we have enough space for those folks that need to come and test in person. And then that space in terms of all our COVID protocols is adequately staffed, but not overstaffed, and that we have things spread out in the right way for everything we might need to do during the pandemic.
And I think lastly, I think one of the things that's important to know too is that of the people that fell into the category of having missed this deadline, despite the reminders, we're talking about roughly 160 people compared to over 2,000 that were able to make that deadline. So
well, we're almost at 4,000, 3,804 as this morning who were approved.
And Audrey, I don't know if you want to add anything about exam soft deadlines that we also have to deal with.
Right, so like I said, the mock exams opened on the 26th, so on Tuesday. That means that we need to send exam soft everyone who's been approved, including accepting the testing conditions for the exam. So we have to know that people are ready to all the different things that have to deal with taking a remote exam and how that is proctored. We need to know those folks are ready for those conditions before we do things like open the mock exams.
So are there any questions related to this?
Yes, definitely. Number one, some of the commenters did highlight that they paid the fee and the fee has not been refunded. So that's something that's of a concern considering they paid their cost to sit for the exam. I believe they could be provided an extension. And I understand deadlines, but I also understand that we're living in a pandemic. That's one of the worst pandemics in our nation's history. We just peaked at deaths this month, and we don't know what's going to happen. So I understand the need for deadlines and why we moved to an online administration. But I also am very, and I emphasize this, very keen to promote compassion, understanding of the applicants. We don't know what they're going through. We don't know what's going on. I know as government, we typically provide all these areas where we believe will remedy these issues. But I think to do something that we did before shows good faith and practice. And I wish we could have already done it so we wouldn't be having this discussion. But I think the fact that we had callers and we spent probably 30 minutes listening to callers telling us about this issue is really a concern of mine. And to hear that it's 100 to 200 people that might have been impacted. I mean, for me, I come from a community where we have lack of access to justice. And so every single lawyer that is provided the opportunity to practice is a life change or a community change. And so I think about that in totality of our nation and of our state, and also about our mission of public protection and access to justice. So I strongly encourage we just provide the extension. We are living in some really hard times right now. And I think we could do this and do it because it's the right thing to do.
And I'd like to make a comment. I'll be brief, of course. As many people, or as many of the members of the community know, I'm a huge stiffer when it comes to technology. And I really side with no guff excuses with technology. That's pro and con for applicants. For this, I side with an extension because the email communication and spam, it's been well documented, in my opinion, based on my own experience with the CalBAR in the past. The first and major note was my acceptance email to this committee was directly sent into my spam folder, and I missed attending one of the first committee meetings because it was in my spam folder. The CalBAR, according to Google, CalBAR has been listed as a known spammer, and this is back in 2018 in August and September time. There's reasons for that, which directly, I guess, dive into my second point for this is Google's anti-spammer filter has been in flux. As you know, I create legal AIs and other stuff. I know my technology. I do know when algorithms do change, and the anti-spammer filters for at least Google, and I believe for Hotmail, for Microsoft equivalent, I do know that they've been altering, and some emails have been getting into my spam folder when they've shown it. And if we want the most recent example of CalBAR getting into my spam folder was about, I think, summer of last year. Of course, I have to whitelist that, but that's just how things are. I really recommend and encourage the State Bar to really have communications with probably Microsoft and Google to understand why the emails have been listed or being listed as spam. Has some of the participants noted, and this is kind of true, that this was sent through Salesforce technology, and so there might be different reasons, but when you do mass emails to participants, primarily for people trying to actually do stuff like, you know, these online examinations, companies like Google and Hotmail will rightfully so mark it as spam because they don't have prior relationships. Three of the major rules, I guess, for an email to hit spam is your IP address has been or is being used for spamming. People like to spoof CalBAR and other emails. That's common. That's why it's been flagged. Second rule is there's a low engagement rate of people clicking on the emails, not primarily for the bar exam, but for the CalBAR emails. Like I receive multiple CalBAR emails. I do click on them. I know a lot of people who do not click on them. That increases the likelihood of it being listed as spam and listed the organization as spam. Third is the from information, which I believe some of the applicant or public comments have addressed. The from information has to, if it shows inaccuracy, it will be more likely to be flagged as spam. And then this is an aside for my second major point, but this is related to technology in general. I really, really encourage the CalBAR and the State Bar of California to switch from an HTTP to an HTTPS address. The S at the end of HTTPS stands for secure. It's a common industry practice. I'm baffled that the State Bar of California still doesn't have an HTTPS address, there's no reason for it to be inaccessibility reasons. That's not an argument anymore, because you can look at other government websites that have HTTPS. The reason why I'm bringing this up is if you don't, Google has clearly stated years past, at least 2 years ago, maybe 3 now, that if you don't have an HTTPS address, then they will derank your website in the search engine algorithms and flag your website and following communications because you aren't following actually common industry practices of security. And that's my main thing. Sorry for that. I side with giving an extension. Those are my things I saw right now that should be at least addressed or looked into. Thank you.
Thank you, Michael. Thank you, Kareem. Amy and Audrey, I was just writing down some of the numbers. Can you again repeat sort of like what was the number this time compared to the previous? I think it was like around 160 or what was the number?
So the number, oh, go ahead, Audrey.
No, yes, of folks who were administratively withdrawn for not returning the form was 161.
And sort of how does that number compare to the previous sort of incident?
In October? Oh, it's lower than the number in October. I would have to, I don't have that number in front of me, but yes, it's significantly lower, hopefully because of all the education campaign we did around the due date.
Right. And I'm just curious, and thanks for sort of sharing all the activities in response to the previous incident, but I'm curious, were there any phone call inquiries or anything done, like, you know, to sort of answer any questions that may have come, not so much via email, but into the office, knowing that, again, some people may choose that sort of channel of communication to get more clarity?
So I want to clarify one thing. So if somebody had called us, let's say the due date on this was on January 15th. If somebody had called us or emailed us on January 11th and we did not get back to them on January 15th, that case was not withdrawn because there was an effort for somebody to contact us. Were there contacts after January 15th? Yes, there were people who had not contacted us prior to that. I think we probably are getting emails from those applicants today.
Thank you. Are there any other comments or questions from Dolores? And you may be muted.
Okay, there goes. It was not letting me unmute. I was being gagged. My question is, does that January 15th date constitute an extension already? Was that an extension date?
No, that was the published deadline since October 10th when we published all the deadlines.
Okay. So then again, out of curiosity, since apparently there was an extension made for the October exam, why wasn't there an extension made for this one?
Well, we changed a lot of our process around this testing conditions form based on the feedback from the October exam. So we changed, I kind of tried to outline some of, we made sure the deadlines were published on the deadlines page. We gave repeated reminders, went to a variety of meetings in December, talking about these deadlines in particular, talking about how to whitelist emails from us. So the process was entirely different to what happened in October based on the feedback from applicants and the public.
And one thing I think we have to recognize too is that the window between when we opened the application for the October exam and when the testing accommodations were due was much smaller than the window we have today. People had over 2 months versus for the October exam, I think it was about 3 weeks. And so that caused us to extend it. So just want to highlight the difference between the October and this exam. And the deadline for the testing accommodation, for the testing conditions, acknowledgement and acceptance notice.
So is there any remedy at this point for those people or not? The 160?
No, they've been administratively withdrawn, but we're bringing it to the committee now or it's come to the committee for discussion. So
This is Shelley Torrielba. I would like to see some kind of remedy extended to these individuals. One, it seems like a relatively low number of people, either an extension or a refund, but it doesn't sit well. And I understand that there's been a change of a way to try to address the concerns from October to February, but it's still a new process, and it doesn't the process or the timeline and the issues with technology and going to spam, it feels like a legitimate issue that still needs to be corrected through no fault of the applicants, or maybe through fault of theirs, where we don't have that information. But the whole, it feels like it's lacking due process, I guess is what I'm trying to say. And that I believe either an extension should be granted to these students, or at a minimum, a refund of their application fee. We're in unprecedented times, and I get that there's been corrective action taken, but still, it's still a significant number of people that were caught in a trap that was created through technology that we are still trying to correct. So I think it would go a long way with goodwill and faith in our system and the efforts that we're making with online testing, and for future use of it, and trusting that what they're participating in is being handled in the most up-to-date manner, and it doesn't seem like we're there yet. So that's my comment.
Mr. Vice Chair, if I may make a comment.
Sure.
Just a clarification. I don't think Audrey had mentioned this. So in addition to in the materials that we provided in the FAQs and a variety of other communications, in addition to suggesting that applicants whitelist the State Bar email addresses, we also indicated, and I don't recall the frequency, Audrey would have to fill me in on this, but I think as I recall, we specifically recommended that they check their spam filter once a week, something like that. Because we know that, this is a problem that we have limited control over, limited to no control over. And if it's going to end up in somebody's spam filter, we wanted to remind them to check the spam filters, in addition to knowing the deadline, since we had posted them. But I just wanted to add that piece.
Great, thanks. Bethany, you wanted to make a comment?
Yes, I did. Thank you, Mr. Vice Chair. I really just I was going to say almost exactly the same thing that Judge Torrielba said, but I wanted to discuss, like, at the bare minimum, what is the barrier to providing a refund to these individuals? Because, can you guys still hear me? Okay, because yeah, I understand the whole issue with the spam, and like, it's probably partially the fault of the applicants, partially the fault of all the mess that the whole country is dealing with right now. But if they're going to be administratively withdrawn for failure to submit the form, then I'm on board with the least we can do is give them back their money, because that's almost $1,000. That's a significant investment for a lot of people. And we know that there's probably a 100% chance that every single one of these individuals is going to re-sign up to take the bar, because that's what they're trying to do. And so I just wanted to open the discussion about what is the barrier to a refund.
Really quickly, if I may interject, Mr. Vice Chair, my understanding is that retakers have until February 1st to submit their acknowledgement. So I don't see no issue with extending it to February 1st. But I also respect that Bethany proposed another remedy. But I believe these test takers want to take this test immediately. So if we can, let's figure out how do we provide an extension first. But I understand Bethany proposed another.
Donna or Amy, maybe can you provide what's the current policy on refunds, or at least what's possible for this group?
Yeah. So what we implemented and what we discussed in our in the material related to missing the acceptance and acknowledgement form deadline was that we were not granting refunds, but there is nothing that you know, if this committee chose to provide a refund, there's nothing that could prevent us from doing that. We could, if you directed us, we would move forward with that. The one thing I do want to say about this reinstating, I think somebody said earlier that it doesn't take much to reinstate folks. It is work on our staff's part. So I just want to highlight that there are resources that would be needed to dedicate to this task. Not to say that we can't do it, but I just do want to highlight that. And also, then we need to be firm on the next set of rules, because if we're going to make an exception here, we do have other deadlines that need to be met within this context, such as completing the mock exam. And again, the mock exam is not for the sake of just completing the mock exam. What the mock exam does is it prepares somebody's laptop for the examination. It prepares, you know, it determines whether somebody's laptop is capable of using ExamSoft for the bar examination. So it's not an arbitrary task or a deadline as well, because we also need to have a sufficient time to deactivate those that do not have a laptop that's ready. So I just want to highlight that would be the next hurdle of deadlines, and we're working against these. As Audrey mentioned when we first opened up, we're 3 weeks away from the exam. We have to process the next group, which is February 1st on Monday. The next people that are going to send their testing accommodations, we're reviewing every single individual one to make sure that if somebody cannot meet the testing conditions, we simply just don't put that application away. Sometimes we engage with our applicants to find out what aspect of the testing condition is challenging to that applicant. It's a process, it's a dialogue sometimes. And so, and then once we evaluate that document, we have this pile of people that we need to review individually to determine whether we can meet their needs in the extenuating circumstances. So again, we had 2 separate deadlines to allow immediate repeaters the ability to offer them the same options that the non-immediate repeaters, so that other bar exam applicants got. And so we can make this happen. I think it's just a matter of figuring out our resources to do so. So, you know, to answer Bethany's question, if the group decided that we could refund people's fees, that should not be a problem for us. It's a matter of having the resources to do that.
Hey, Mr. Chair, if I may, with respect to the recommendation made by Bethany, and with respect to your comment, Amy, what would the form of the motion be to provide what type of refund, and how would that be?
So I'll just jump in here because as we covered earlier, this isn't specifically agendized for today's meeting. So the committee actually cannot take action on this at today's meeting. Typically the chair, or in this case today, Alex, could you know, request a future meeting where this was agendized. If the committee felt like it met the criteria for a special meeting, you could do it with less notice than 10 days, but you'd still need a minimum of 48 hours notice. But because we have this February 2021 California bar exam report from staff, I think this is a good opportunity for, you know, staff to explain the February 2021 deadlines, and then the committee to provide some feedback about you know, what they think about those deadlines and the public comment that we received. But just so we're clear, we can't actually take motions on this because we haven't given the public adequate notice of any action on the item at this point.
And I understood, Mr. Chair, then I would ask that perhaps we address this issue forthwith.
Yeah, David, and can you just hold that? Paul, give one last comment. He had his hand raised for quite a while, and then can I come back to you, David?
Sure.
Yeah, I was just going to say that to avoid the problems with spam emails in the future, ask staff to consider building all of this into the Ames interface so that when an applicant goes to their portal, they can see what they're missing and then initiate, responding to that need to supply something right there. And then you could simply tell them, look every week to make sure that, you're still ready to take the exam, as opposed to farming it out via other avenues where, things can go wrong.
Maybe Audrey could help address this, but the application is in the applicant's portal. One of the things that we did not have for the October exam was a method to alert somebody that testing conditions, the requirement has been satisfied, and we were able to do that at this point. But and Audrey, can you correct me if I'm wrong, but you can access your completed form in the portal itself.
No, that's good feedback from Paul. And I've actually been working with IT to make sure that we can, what you get back from us is when it's been submitted. That was feedback that we got from October. You get a message saying your form has been submitted, so people have a record of completing the form. But I think what Paul's mentioning and what we are working to enhance is that everything shows up in the portal as well.
A one-stop shop.
Yeah, I think that's good feedback, and that is definitely what we are currently working on with our IT department.
Can I work with?
Great. So, David, let's circle back to you, and then we can move on. But go ahead, David.
I'm not sure what how difficult it would be given the fact that we've got a bar exam coming up. However, let me just toss this out to the possibility of addressing this issue either within 10 days or at our next meeting, but keeping that possibility open to reimburse some of these individuals.
Yeah, I agree with you. And I think because I know all the time constraints as well as sort of responsibilities on the staff, I think at the next meeting that we do have, at least now instructing or asking the staff to explore what is necessary for conducting and executing on a reimbursement plan. Does that sound fair?
Thank you, Mr. Vice Chair.
Yes.
Mr. Vice Chair, just real quick, can I work with, I'd like to request working with Audrey Ching and IT department to see if I can fix the spam for the upcoming administration, plus about the website concerns I brought up earlier.
Audrey, would you be open to that, you and the staff?
Yeah, I mean, Michael seems to have a lot of knowledge that would be helpful, so thank you.
Okay.
I like to fix things so we won't have a repeat of this.
Thank
When
you.
you're done there, come to my office.
Right. Okay.
I charge you for that.
And then
So I just want, Mr. Chair,
Yes.
I have a question real quick. So just for clarity, we're not looking at granting an extension to the 161 applicants, even though there's a deadline of February 1st for retakers that could be lumped in. That we could not even have to discuss reimbursement if we provide an extension of even 2 days, 3 days. Knowing
Right,
that we
yeah.
have technical problems. So I just want that to be very clear. I know the public's listening, and so I just want to be very clear because this is people's lives on the line. So I just want
Yeah,
to be
this is-
mindful of that.
This was focusing primarily on the reimbursement.
I had requested to put on the agenda this item specifically. Of course, it might have not have met the threshold, but I would definitely prefer that we talk about both issues. I'm disappointed that we won't provide an extension, but I get it. We did hear from 4 representatives, actually 5, including myself, that an extension should be provided. And so I think there is, other discussions that we need to have regarding this.
I know you mentioned earlier about it. Your request was not honored. So I don't think it's out of question to say having it serve as an agenda item on the next meeting. Is that fair?
Carolyn said
Is that
that.
what you're asking for? I'm sorry, go ahead, Bethany.
Bethany had some.
So
We could do it
Is-
in
is
48
that-
hours.
Yeah, I would do it in 48 hours. You could count me in. I will be there. And,
that would be
anything
Monday.
you need from me.
So
Yeah.
generally, if a majority of the body or if the chair wants to call a meeting, then that would be, you know, sufficient to call a meeting. For the special meeting, just remember, you have to make findings during the meeting that it meets essentially the requirement, which is that it would cause an undue burden to the agency to wait the 10 days. Or it would be against the public interest. So just reminding you guys about the extra procedures related to the special meeting. But so generally speaking, either a majority of the body or the chair would have to call such a meeting, or as Alex suggested, an agenda item can be placed on the next regularly scheduled meeting.
So it didn't sound like, at least Bethany and Cream, that having an agendized for the next meeting would meet that time frame because of the urgency, right?
I think March is after the deadline, if you ask me, Mr. Chair, respectfully. I think this needs to be done immediately.
And then Caroline, I'm sorry, it was sort of cutting out on my end, but you were talking about and outlining, say, what would need to occur, say, within a 48-hour time frame, who would have to be involved or what communication has to be set forth.
So
Would you mind repeating that?
Yeah, if the committee wants to have a special meeting to address this in 48 hours notice to the public, then typically a majority of the body would have to want to call that meeting, or the chair could call that meeting. Or you know, if you wanted to continue to discuss a little bit or ask questions of staff to get a sense of like sort of what's possible during this meeting, we can do that. But yeah, at least a majority would have to want to move forward with the special meeting.
So I think, you know, just listening to the feedback and comments from the committee members, I think that it is something of concern for a majority. And I don't think it's out of question. And since I do have that ability to perhaps call a meeting, given the 48-hour notice to the public, sometime possibly next week, but not necessarily focusing on a specific day unless we need to do that now. Is that fair to sort of set that up as an ideal plan?
Well, we would just need to, so we can get people's availability on staff's end, and then we just need to make sure that we post the agenda with 48 hours notice to the public. So, you know, if we can get information about people's availability soon, we can do that sooner. If it takes a little while to gather that, it might take a little longer, but basically that's what we're looking at.
And would a quorum be needed to
Yes.
attend that meeting?
Mr.
So
Vice
is
Chair,
it?
I'm sorry,
Yes.
this is Shelley again. I would say that we meet the criteria of the necessity and the undue burden on the committee due to the upcoming bar exam of February 23rd and 24th and the repeat takers submission deadline of February 1st. So if any extensions are going to be granted, it would need to be done in an expedited manner to allow individuals time to be able to prepare to take the exam. So I believe that we meet all of the requirements to call a special meeting. And I think we could just pick the date and take a roll call right now and have everybody go ahead and submit, advise that they're available, and when you get a quorum, go forward.
I agree. I think we can do that right now.
The only other, oh, sorry, there was one other thing I wanted to say that was another possibility. So if staff wants to reconsider, you know, making an extension to the deadline or anything like that, because that tends to be in staff's jurisdiction, they could also, you know, take proposals now, take it under consideration, and then on their end decide to, go ahead and execute that without the need to do a further meeting. So I'm just letting you know as an alternative, like if there was general agreement among the committee today about what should be done and they communicate that to staff, like we might not necessarily need to go forward with the full meeting because staff can go ahead and possibly do that. And if you're going to vote on it anyway and direct staff to do it, it's kind of like it's the same outcome, if you get what I'm saying.
And that was what I was pointing to, that this could be solved today and right now in this moment just by providing an extension easily, and we don't have to have a meeting.
Yeah, the only problem is like you can't really take a vote on what to do. So it just have to be kind of an informal consensus about what should have to be done and then some agreement on the part of staff. So that's, I'll just say it's not a formal action of the committee in that event.
Yeah, I have a question, sort of a comment, which is, the pandemic has given the governor and the president and I would assume the courts latitude in making these decisions on an emergency basis. I don't see why this is any different.
So and Kareem had mentioned the executive orders from Governor Newsom, sorry. The issue is there's no waiver of the 10-day notice requirement. You still either have to have 10 days notice or you have to have the 48 hours for a special meeting. So even though there's been other sort of consolations or I guess like flexibility given the situation, that the notice requirement has not been waived. So we're
right.
still.
That's true if the committee meets, but there's nothing stopping staff from making an executive decision.
Oh, right.
Correct?
And that's what I was saying. So that's the alternative option is like if the committee came to some kind of informal consensus and then made a proposal to staff and staff accepted it, like then yeah, that's a different situation. But I know that staff also just spent a lot of time sort of explaining all the reasons for the deadlines and everything. So and I wouldn't expect that staff would be in a position to make a decision on the spot about the issue. So I don't know. I put it forth as a possibility. Maybe they could look at the numbers and talk internally like at lunchtime and then come back and indicate one way or the other. But it's an alternative to the going forward with the full meeting and all that stuff.
Well, that would be my recommendation, to do it that way, because it's just be a lot easier and it makes sense. It's common sense.
So yeah, it sounds, I think from the sense and time urgency, this is something, especially since we have everyone here, that we could, at least from the committee side, come with a recommended send up action items that I won't say at a high level, but that the staff could also consider today. I don't, to put the burden on it, say at lunchtime for only 30, 40, I don't know if that's feasible, but maybe it is possible. We'd like to get sort of staff's input on this and then circle back after lunch on it with a go forward plan. Is that reasonable?
Yes, we do working lunches all the time. So I mean, not to minimize anyone's personal time, but we're all committed to this committee for today and know that this was going to be something that we needed to consider. So I would urge staff to provide as much information as they can after the lunch break for us, so that we can try to act on this today. It is an urgent matter. Time really is of the essence.
Yeah. Amy, is that feasible for you and your staff?
So the request is for us to revisit this at lunch internally to make a determination whether we can extend the deadline or allow for the refund, because that's feasible.
Yes.
Yes.
Thank you.
Great, thank you.
Thank you.
On the issue of the refund of the money, would it make it any easier for staff to give them the option of having the money refunded or giving them credit for a future bar exam? Do you ever do that?
No, our system, every single exam is built in. And so we don't have a way of like banking somebody's fees for the next exam. It requires a reimbursement.
Okay.
Mm-hmm. All right.
Okay, Great, thank you. So just look, any interest of time, I'd like to move forward on the next agenda item with a report from Bethany.
All right, so myself, Alex, Michael, and Dr. Bolton are on the differential item functioning, I guess, task force. For the benefit of members of the public and people on the committee like me who had never heard the words differential item functioning before it was raised a couple months ago here, just a quick, I guess, summary of what it is. So essentially, it's an analysis form where you're looking at items, in our case, test questions, to determine whether or not individuals who are the same in most respects are performing differently on these questions. And the analysts don't like using the term bias related to DIF, but that's kind of, you know, from our purposes, we're looking for ways to expand access to the legal profession. And one of those ways is what we know we're doing from a variety of aspects is reevaluating the bar exam. So our committee, or our task force, it's half CBE and half members from the Council on Access and Fairness. And so we're going to be reviewing the results of a study the State Bar had performed by the Scantron Corporation, wherein they evaluated the performance test and the essay questions, because those are the only questions that we are in control of here in California. We don't do the MBE. And we're going to look at those to determine whether or not there is DIF with certain questions, and then kind of try to brainstorm ways and policies that we can recommend to eliminate that. Because obviously what we don't want is people not performing well on the bar exam, not to do with their legal understanding, but to do with other cultural and outside functions. So basically we had our first meeting, we kind of talked about some of this broadly. We decided that we needed to bring in some people. And so at our next meeting, we're bringing in a representative from Scantron to explain to us what they did and how we can have different, you know, methods and tools to analyze the data that they have provided us. Our next meeting is not going to be until mid-April probably, so we won't have an update at our March meeting, so don't ask. But the next meeting after that, we'll have more to report back.
Great, thanks, Bethany. Any questions or comments? And that was, you're working with Alex Chan, not me, within that group, right?
Yes, Alex Chan.
I'd like to volunteer to be on that committee if that's allowable.
This is Shelley Torrielba. I would love to too. I'm very interested in that committee.
I think, Amy, correct me if I'm wrong, they had sent out a call before you were on, Dr. Wilcoxon, for volunteers. And so the four of us had volunteered. I don't know if it's still open, Amy.
Yeah, I mean, we've officially met, but I don't want to discourage anybody from, you know, at least attending and participating, you know, as a member. I mean, it's these meetings are open to the public and obviously open to our committee. So I don't think that should be a problem.
So when we schedule our next meeting, we can share that info with the committee. So that way those that want to join us can. We haven't picked the next date yet.
Yes, absolutely.
Great, all right. Thanks, Bethany. And perhaps we can do just one more item before lunch. It's the examination goals, approval of the 2020-21 examination goals. I want to turn it over to the chair, James Epting.
Sorry about that. Okay, so this is Jim Efting. We have the goals which were set on Open 200. I believe they're pretty much the same as last time, except that I think item number 10 was added. Work with State Bar Office of Access and Inclusion and Council on Access and Fairness to develop procedures, processes and procedures and examination development, which I think just covers what we just talked about at the last meeting. Does anybody else have any other particular questions about the goals or examination goals? Did you have any comments, Lisa?
I don't. Thanks, Jim.
Great. Ms. Wong, can we take a roll call? for
We need a
approval of the goals.
motion First, Mr. Vice Chair, we need a motion. Who's gonna,
Sorry, yes. Is there a motion? Is
I'll move to approve the goals.
there a second?
James Bolton, second.
thank you. Okay, Dr. Bolton,
Here, yes.
Judge Brody, Dr. Cow,
Yes.
Mr. Chen, Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kramer,
Yes.
Vice Chair, Mr. Lawrence,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Torriaba,
Yes.
Mr. Torres,
Yes.
and Dr. Wilkinson.
Yes.
The motion passes.
Thank you, Ms. Wong. So it's 11:50. I thought it would be best to, let's take a break for lunch until 12:30. That'll also give staff a little bit more time on the activity that we just mentioned. So at 12:30, please return to this meeting using the Zoom link that was provided earlier, the open public meeting. And then we will continue our discussion and meeting, starting off with, let me open up my agenda here. O&M and Tammy and Judge Torriaba. So thank you, everyone. See you back here at 12:30. Thank you.
Thank you.
Okay, I see Mr. Brody. That's great. All right, on time like usual.
I wouldn't miss this roller coaster.
Like I told Dr. Cox earlier that, hey, get on the roller coaster, right?
All right, exactly.
Does the bird have a mate?
Yeah. The bird is a solo.
Solo.
Maybe that's why she's always crying.
She's too pretty for that.
Yeah. Hey, that's Dr. Bolton. Here, you want to see?
There you go. Very pretty. You've had her about how long?
Long. That's 9 years.
Oh, wow. Okay.
They only live 75 years, so
Oh my God.
yeah, I'll tell you.
Well, that's quite a challenge for you then.
I didn't realize I'd lucky I'm still in my 20s.
So Alex, Paul's attention might be turned away just for a moment. If he is not here at the start of Ed Standards, he'll be here soon. We might have to do a little switch if you don't see him,
Okay.
but he'll be here
And-
momentarily after
Okay.
O&M. He hopes to be back in time.
Well, that's the sort of a little bit of the curveball. I wanted to start with Ed Standards first, but that doesn't seem like that may be possible. Or how long?
He was thinking he had the time of O&M. It sounds like maybe 15 to 20 minutes. I'm sorry, I just got this information myself.
Yeah, no, I understand. And Amy, I don't know if you just heard, but Tammy's not available right now for a little bit, right?
Yes, I, want to get back on the staff discussion that we just had. And it's pulled Tammy away for a bit, so.
But we can start, we can start with that chapter 6 presentation as well, since I'm the one giving that one. So if we wanted to skip around, we could do that and then go to Ed Standards and then come back to Tammy.
Yeah, that will buy us some time. Either Tammy's back or we can move into Ed Standards, whichever happens first. Does that sound like a plan?
Yes.
Okay, great. So let me know when we're ready to start.
Sure. Let's see what time it is. Oh, yes, let's start. You start the recording, Kim, and then take roll.
Dr. Bolton,
Here.
Judge Brody,
Here.
Dr. Cow,
Here.
Alex Chen, Mr. Efting,
Present.
Mr. Gongora,
Present.
Ms. Heisinger,
Here.
Mr. Iseri,
Here.
Mr. Kaplan,
Here.
Mr. Kramer, Ms. Pick, Mr. Reyes,
Here.
Judge Toriaba, Mr. Torres, and Dr. Wilkinson.
Kim, this is Bethany. Sorry, I'm having technical issues. Present though.
Okay, thank you.
This is Shelley. I'm present also. Sorry.
Okay, great.
I'm here as well.
Okay, great. We have a quorum. Mr.
Great. Great. Thank you, Ms. Wong. Welcome back, everyone. This is open session, and staff are working on some items related to our discussion earlier this morning. So we're going to jump a little bit in the agenda as is shown here and actually go to a presentation by Audrey Ching. Audrey, I'll turn it over to you.
Alex, sorry.
Yes.
But we could report back on the discussion that we had related to the testing conditions deadline.
Sure.
Would that
Sure,
be
go ahead,
helpful
Amy.
to know?
Yes.
Okay, sure. So, I just want to start with saying that we've certainly heard that some number of the 160 individuals who failed to submit the testing conditions document were not aware of the deadline and remain interested in taking the February bar exam. We also understand the importance of being able to sit for the exam when you prepared for it. And so I do want to highlight, and I think it's important to note, again, that staff made extensive efforts to post the deadlines timely. We did that very early October. We recommended that individuals whitelist CalBAR email addresses, and will continue to do so as we look also for other remedies in the future related to that. We also want to remind people to check their spam filters at least weekly, because that will help eliminate this type of situation in the future. And we also send multiple email reminders. Right now, we have communication on a weekly basis. We send out a Friday email on important deadlines that are coming up. And so the other thing to note is that these deadlines are not arbitrary. As I mentioned earlier, there's extensive work that needs to be done to reinstate the 160 individuals. So we're planning on doing that, and we're going to inform them that they've been reinstated, and review the additional documents that come in as they are received. And we're going to communicate with the applicants as necessary about remote versus in-person testing and other logistical challenges. So we determined that we're going to extend the application to align with the February 1st deadline for immediate repeaters. But that the remaining deadlines and other related requirements are going to stay the same in order for us to be able to effectively deliver this exam. As I mentioned earlier, there's several steps post this testing conditions document that need to happen. But we're going to extend this to February 1st for those 161 individuals. So I just wanted to let the committee know that that is what our staff are able to do now.
Kudos to staff, and thank you for providing that information. I'm sure that those 161 individuals, whether or not they take advantage of the situation or not, will be relieved to get this information. So thank you very much for your hard work and diligence, and your anticipated hard work and diligence. I completely understand what it takes to make a large ship turn on a dime. So your words are not lost on me for sure. So thank you.
Thank you for that,
Thank
Amy.
you.
I appreciate staff's willingness to listen and to definitely move in this direction. Just for clarity, I believe another email will be sent to applicants. And so I just want to make sure that that's clear, just so, if anyone's listening, they kind of understand the importance of that.
So what we're doing now, we have to do the behind the scenes to reinstate and unexpire those custom links for applicants. And then we will send the communication, not only to the 160, but there's also the immediate repeaters that are due on February 1st. So just so everyone's clear about what Amy was just saying about deadlines, so February 1st, 11:59, we're going to add in the 160 to the immediate repeater pool. And then after that deadline, anyone who fails to submit the testing conditions document will be administratively withdrawn.
Understood. Thank you for that clarification.
Thank you, Amy and staff. And Audrey, want to turn it back over to you. You have a presentation.
I do. Okay, so we're skipping because Tammy obviously is over this area that needs to work now on withdrawing, reinstating, making sure that everything aligns in our system to make this lunchtime discussion happen. So we're skipping around, and I apologize for everyone who's following the agenda. But there's an item under operations and management. It's discussion of the Chapter 6 review process for the October 2020 bar exam. It's under Tammy, but I've actually prepared a slideshow. Very exciting, hopefully, for everyone. 1 second. Let me share my screen. Okay, can everyone see my slides?
Yes.
Okay, great. So I want to talk through the October 2020 bar exam chapter 6 process. And I know we have a new committee member. So just to start level setting about what chapter 6 even is, and you know how it is when you work somewhere, you kind of get so used to what you're talking about. It's kind of helpful to unpack it from the beginning. So chapter 6 is chapter 6 of the admissions rules. This chapter covers exam conduct, and these are all references if you wanted to look up in the guidelines, how we handle reports of conduct violations. We will notice applicants of a conduct violation and then give them time to respond, and then assign sanctions based on review of the notice and review of response. There's also a process for administrative hearings under Rule 4.73, and then these guidelines, and a review of findings. So this is just sort of setting the table. We also have a decision matrix. This matrix was devised initially with the in-person exam in mind. And then we met, and as you might remember if you were here in the summer, we met in advance of the first remote exam in June, the first year law students exam, to revise the matrix in light of how the proctoring would work with the video proctoring element of the remote test. We brought the matrix back to the CBE before the review of remote bar exam proctoring videos to make a few tweaks. For example, you might remember that we deleted out references to animals in the room being a violation. So that's just an example of things as we iterate on giving remote exams, we do want to be responsive to things that we find over time and make changes. We also published post-exam FAQs. They're posted for the public, including the matrix, including the chapter 6 rules. It's all there. So applicants, law schools, anyone in the public can review what does it mean when we refer to chapter 6 at the Office of Admissions. So we had the October video proctoring. Obviously, I want to review for you how that went. So after the ExamSoft initial review, we had 3,190 applicants out of the 8,920 who completed the exam online. 3,190 of them were flagged in the software. So that's about 35% of applicants with flags, which was a large reduction percentage-wise from the first year law students exam, where we had over 90% of the applicants for that exam flagged. Still, obviously, when you say 3,190, you would say that's a large number of applicants, but percentage-wise, it was actually greatly reduced. The 3,190 applicants, their videos for review were divided between Office of Admissions staff and trained experienced proctors that we brought back just to review the videos. 432 Chapter 6 notices were sent out from that review. And just to remind you, a notice is a chance to respond. You have 10 days to respond from the notice, and it's not a determination. So the notice itself says that this has been observed, possible violation, and then you have 10 days to respond.
Yeah, it was like 50, but the meat in the freezer from the garage was.
Paul, I think that you. Paul?
Yeah, sorry, I thought I was muted.
That's okay.
Hey, Audrey, this is Robbie. Can I stop you real quick?
Of course you can.
So so it sounds like you sent out notices to like 15%, between 10 and 15% of the ones that were flagged.
The math on 432 between 3,190?
Right, so does that mean that the other 2,900 or whatever, those were determined to be kind of false flags?
Right, so yeah, that's why we do our review. I don't know, they're not false. I guess it's kind of confusing because there might be, the flag might be valid based on the parameters of why it's flagged, right? So if the flag, on the ExamSoft side is about, this camera's misaligned, then the camera's misaligned, right? So that's a flag, but we can review it on our end and determine whether or not that notice actually needs to be written for whatever the duration was of how long it was missing. You know, so there's judgment on our end reviewing those flags.
So and again, just so that I'm clear, so the ones, the majority of the ones that were flagged, a determination was made that there was nothing there that would have impacted the integrity of the test taking of that applicant of the exam.
Right, so that we would, when we reviewed them, we did not need to issue a notice and wait for their response about what we observed.
Yes. Oh, okay. Well, I think that so far that's a great thing. Okay. Now,
Okay.
now getting to the bad part.
Well, I don't know. It's just the facts. So we
Okay.
had 432 applicant videos then that were noticed. Then we also had the responses from the applicant about the notice. So the responses and the videos were reviewed by management teams. And so specifically, you know, Amy and I and Tammy, along with others on these management teams, watched all of these videos and all of these and read all the responses. Out of that review, 48 Chapter 6 notices were affirmed. So affirmed means a sanction is assigned. And if you have the decision matrix or you want to open it, you know, whenever you want to look at it, you can see what the sanctions are possible. The possible sanctions are on the matrix. So affirmed means a sanction is assigned. We also had 3 additional Chapter 6 notices where applicants had no proctoring videos to review. And those were affirmed because there was nothing uploaded to review. So the process was complete before we had the accelerated release of results on January 8th. And applicants whose notices were affirmed had their grades released as well. So we were able to meet that early deadline. Yes? Oh, sorry. So we were able to get that early deadline of release and kind of dovetail the proctoring review process and the Chapter 6 process along with that. So common affirmed notices, leaving camera view, getting up from the exam area for an extended duration. So not maybe someone, you know, bend over, sneezing and coming back, but an extended period of time where they were just gone from the camera. Having paper in sessions other than the PT, obviously we allowed for paper in the performance test, but individuals who had paper in other exam sessions were affirmed. Pen as well in other exam sessions, and electronic devices. And these are just common reasons that violations were affirmed. So since the October exam, we have had another process. So we had you'll remember we had the November baby bar, not October, because we had to move the baby bar for the October bar exam. So we iterated on the October process. You know, we're trying to, as we go through these processes, we're learning how iterative it is based on what we've seen over time. So we revised the forms and the review process. So we still had the staff reviewing the flagged videos, but we waited to issue the Chapter 6 notices until the management team reviewed the incident reports. So, so before the Chapter 6 notice was issued, I reviewed the incident reports and those escalated videos. So there was a much smaller pool of applicants, 298 that completed the exam online. 103 of them had flags. That's about the same percentage as the October exam. 20 incident reports to review, and 4 Chapter 6 notices have been issued. They still have time, I believe it's sometime early next week where that 10-day period will expire, but they still have time to respond before we issue or don't issue anything with affirming their notice. I think that's the end, but I'm going to leave this up because anyone wants to go back, because I know I said lots of numbers and I'm talking about a process that is also a number, Chapter 6. So I want to make sure that we, I can go back if you have other questions.
Audrey, can I just highlight a couple of things for the committee? Sure. So when you look at our November numbers here, as Audrey's pointed out, it's a much smaller pool of applicants. We had about, let's say, roughly 300. 103 were flagged. representing 34.5%. So let's say roughly a third. That's exactly what happened with the October exam. Of those 8,000, it was about a third, because I think there were concerns about how many people were flagged. When you start looking at the from the number of flags that were reviewed and reduce it down to how many people were noticed, those numbers start dropping. And so for the October exam, when you start looking at the total number of flags and the total number of people who took the exam, and we look at how many people actually received a sanction, that is, we affirmed that their Chapter 6 notice that there was a violation of the testing rules. It was a 0.5%, so less than 1% of exam takers received that. And I just want to highlight that because I think there's been some misunderstanding about your review process and who was noticed and how that process went. So I just want to put that out there and highlight that for the group.
Any other questions? I want to be responsive. I know this was something that had some interest, obviously, from the media as well. So I want to make sure that we're as transparent as possible on our process.
Thanks, Audrey. Are there any comments, any other questions? Okay, are you done? Audrey, any more information you want to provide?
That's the information. Thank you. And I think also we have Paul back now, so.
Oh, great. So we're going to make a move to Ed Standards. So turn it over to Paul Kramer and Natalie Leonard.
Okay, hearing me?
Yes.
Yes.
Okay, good, thanks. Just as in December, I'm going to take the 3 schools who have the same issue more or less together, although I will ask at the end if anyone wants to separate out individual schools for individual votes on the proposed actions. But by way of background, at our December meeting, we considered notices of non-compliance for these 3 schools, which are John F. Kennedy University School of Law at North Central University, Lincoln Law School of San Jose, and San Francisco Law School. Notice of compliance for them, and we determined that their responses were unsatisfactory regarding compliance with the requirement to maintain a minimum cumulative bar exam passage rate of 40% or greater, found in Rule 4.160 subpart N. Under our non-compliance procedures, which are found in Rule 4.170 and following, the next step was to schedule an inspection by the senior executive. Those inspections were conducted earlier this month with Alex Chan and Larry Kaplan serving along with Natalie on behalf of the senior executive. Today, the inspection reports and recommendations are before the committee to determine whether the schools are in compliance. That's one option. Whether they should be placed on probation, that's a second option. And the third option is to have their accreditations terminated. To recap the numbers, JFK University's 2020 NPR was 39.7%. That's just a little bit below the standard, but below it nonetheless. As with many schools, its NPR was seeing a downward trend from 48.8% in 2018 to 44.4% in 2019, and then 39.7% in 2020. Lincoln had the same experience, going from a 55.4% NPR in 2018 to 44% in 2019 and 30.9% in 2020. San Francisco, same story there, 46.2% in 2018, 41.7% in 2019, and 36% in 2020. The staff reports and inspection reports were linked to the agenda. They describe the various measures that the schools are or will be taking to raise their NPRs. and each of the schools projects that its NPR will return to compliance status by 2022 or sooner. As a reminder, NPRs are reported in basically in June with a deadline of July 1, and they cover the period of the previous July and February bar exams. The inspection teams recommend that we find each school is out of compliance and place them on probation through July 1 of 2022, which would be the end again of the 2022 NPR reporting period. The recommended terms of probation, which are found in the proposed motion school, they're repeated at several places in the reports actually, but I want to focus for purposes of our discussion and voting just on the proposed motion. So we're looking at a uniform set of well, requirements and deadlines, etc. Two highlights are that we're going to test for compliance at the time of the filing of the NPR reports following the release of the February 2021 and February 2022 bar exam results. We're not, because the NPR is calculated annually, we do not propose to test based on the results of the October 2020 or the July 2021 exams. And then the second requirement is that each school must give notice of its probationary status to its students, prospective students, and the public. There's a proposed language for that disclosure in the proposed motion, as well as more detailed example of the types of communications that the requirement applies to, but I won't bother to read that here. The proposed motions are vague on one point that I believe needs clarification. Natalie, can you put up your the language?
Sure. I'm going to bring it up now.
Okay, and while she's doing that, I'll continue on. My concern is that the language could be read to the effect that termination of probation after reaching an NPR of 40% is self-executing. And by that, I mean that probation terminates as soon as the goal is reached without any further action by the committee. But that's not consistent with our rules, however, which require that the committee examine whether to end probation or move to terminate accreditation, which is in rule 4.172 subpart D. The change to the language that you see on the screen there, in my view, makes that more clear that we have to act. And it does say that we will act. It doesn't. So hopefully that gives some comfort to the schools that after they reach the goal, and we've confirmed that they've reached the goal, that their probation would end relatively soon thereafter. Now I'd like to offer Alex and Larry an opportunity to comment since they were part of the inspection team. So guys, does either one of you want to say something?
Alex, Shan, or Larry, you guys want to comment?
I'm sorry.
At all?
Yeah. Are they there?
They're here, at least noted on the screen, but maybe they don't have any comments.
Okay, well, I thought they wanted to say just a little bit, but
Yeah, I have nothing to add.
Okay, thanks.
I mean, the main thing I was concerned about was the disclosure that, you know, prospective students know what they're getting, know what they're buying. And that was covered in the report.
Okay. So then there is an additional issue that was raised in the public comment and both orally today and then by a couple of written comments that were forwarded to us, I think this morning by Kim, which largely track with the oral comments. And those relate to the yesterday's Supreme Court action to allow 1390 and above bar exam scores who did not pass to participate in the provisionally licensed lawyer program, and after putting in 300 hours of supervised practice and satisfying all the other requirements that a traditional bar passer would have to satisfy, except for passing the bar exam, they would be allowed to be sworn in as a full regular member of the bar. The schools are asking both to be able to count those 1390s from previous years as bar passers, or I think an alternative was proposed that we just not count them as students in the denominator of the equation, if you will. You come to 40% by, on the top of the equation, you have the number of people that have passed the bar exam. And let's say for simplicity's sake, that's 5 people. And then you count the number of graduates during the relevant window who took the bar exam at least once. And so what they're saying is, well, these people who are going to go through this program are not going to attempt to take the bar again. So therefore, they're never going to be passers. They think that's going to disadvantage them. I understand that staff and council believes that unless the rules were changed, they don't apply to this situation because the Supreme Court hasn't labeled these people bar passers. I guess a second thought would be that as of the time for calculating the 2020 NPR, which was after the results of the February 2020 bar exam were released, this program wasn't even imagined. I'm not sure of my dates, but I think the Supreme Court may have asked us to create the PLL program before July of last year, but that was only to provide a temporary ability for graduates to work as lawyers under supervision while they were continuing to work towards passing the bar exam. It was only later, probably in October or November, that the idea of making this what they call a pathway to licensure was even broached for the first time by their representative at the end of one of our working group meetings with 3 minutes to go. What I've come around to, at least personally, is the conclusion that while going forward, it may or may not be appropriate to do something to account for the 1390s. As to the 2020 NPR, which is what we are considering today, whether the schools were compliant or not, I don't see the relevance. Ken Holloway, did you want to comment at all? Did I get the gist of your legal interpretation, or
yeah,
do you want to add to that?
I think you've captured it well, Paul. I think we have a situation where we have a once a year determination of the NPR. As you said, that was, for all intents and purposes, locked in when it was reported. And we have a set of guidelines and rules that provide very clearly that it's about counting bar passers. So that's the situation that we're dealing with today. It's what's before the committee, as Paul teed up, is essentially 3 options. It's a question of, is there compliance as of that NPR that was reported? If there is no compliance, then it's termination of accreditation unless progress is shown towards compliance, in which case probation is appropriate. And as the committee's done before, we look at the plans the school puts together to address the NPR to satisfy that requirement in the rules of progress towards compliance. So that's the full kind of range of what we're dealing with for this, and it's I agree with Paul's analysis that it's pretty black and white for what we're dealing with today.
I'm a little confused. You're saying that the lowering of the cut score that the court did yesterday, retroactive, does not impact the findings regarding NPR with the 3 schools we're talking about?
That's correct. And we tried to tease this, someone tried to tease this out earlier in the meeting as well, that the court's order does not make any finding that people who got 1390 or higher in the past are considered bar passers in any form. And that's what the rules and guidelines as they currently stand, that's what the guidelines set out for the calculation of the NPR.
So they're only considered bar passers if they got 1390 or better, plus did the 300 hours of apprenticeship.
So even in that case, they're not a bar passer, actually, Larry, because they would never appear on a pass list. They have an alternative pathway to licensure, I guess might be the easiest way to say it. But the way the guidelines are written is about the passage of the individual exam administration.
So they become members of the bar, but they're not necessarily bar passers. Okay.
Correct. And I mean, that is what's causing the concern looking forward in terms of how the guidelines are looking. The concern that a person who got 1391 last year is going to have no motivation to take the test again, and so they stay on the NPR calculation for the 5-year period, even though they have no motivation to turn that fail into a pass. So that's the concern that the schools are raising, but it's not really before the committee in terms of the decisions that have to be made in our opinion.
I get the logic behind that, but I'll bet dollars to donuts those 3 schools are going to, oppose or object to our interpretation of that in terms of how it impacts their NPR.
Yeah, I am not necessarily a fan of that opinion. I think it's it's very unfair, I guess, to take it in that perspective. And I think it's incumbent upon us to make that clarification because I think the Supreme Court gave a really wide-ranging sweeping reform as to how applicants will be administered moving forward, considering that the PLL program. I do think that we might have to consider what that looks like for the schools that we've already suspended accreditation for, and what that means. And I guess I know this just happened yesterday, but did we make a list of those schools that would be impacted by this, aside from the 3 we're discussing today? I think that students that do, or applicants that do become qualified for the PLL program would be essentially bar passers, because they took they got the 1390, and they also will do the additional threshold to meet the criteria. So it's going to be interesting to see how we assess this as a group, because it's ultimately up to us for the most part to admit them to the bar. And so I don't know. That doesn't sit well with me, because from the way I read the executive order, it was a lot differently.
What recourse? Let's say the schools say, no, the way you've interpreted this thing is wrong. Our NPR is different now because of the change. Blah blah blah. What's their what are their remedies in terms of objecting to the findings?
Jen? So they can file a petition, as with any final order of the committee, which we went through that process previously, however many months ago that was. So it would be the same as any other final committee decision.
Yeah, and I do want to be clear. I think what Ken's suggesting is that going forward, it may be entirely appropriate to say that if you are in this expanded provisional licensure program, right, the one that has a pathway to licensure, if you're in that, then it may make sense to revise the formula for the NPR calculation formula, because if they're in that program going forward, then they're not going to be they're not going to continue to be taking the bar. And so you don't want to count them as having, sort of not taking the bar when they're not going to be taking the bar because they're in the PLL program. But I also think, to be clear, Kareem, what we're saying, so the court did not say that if you got a 1390 going back to July 2015, you have passed the bar, you are admitted to the bar. The court created a special program that said, for those people who got that score, get 300 hours of supervised practice and meet these other requirements, and then you'll be admitted. But it doesn't sort of change the fact, sort of going back to going over the sort of the 5-year period that the current NPR was calculated. It doesn't change the fact that during that period of time, these folks, X number of people were took the bar, and Y number of people were from the school were eligible to take the bar, and so their pass rate was less than that. That all happened. That was true. The fact that we created this provisional licensure program with a pathway to licensure, I would argue, does not change the 2020 NPR, the current NPR, though it does really give us a real impetus to think about looking at the formula going forward.
I mean, this is Natalie. I might also offer an additional point and clarification, in part also for our new member. I don't mean to cast dispersion on any particular graduate's achievement, and look forward to those who will become licensed through this program. But what we're really focusing on here is communication by the schools. And so when the school is accredited, and the state bar and through the committee puts that accreditation on the school, part of what you're saying is this is a school where if you attend, you can be confident that this school has a 5-year cumulative pass rate of 40% or greater. And so part of our question is whether you're wanting to give notice to the students that this hasn't been true at this school in 2020, back before the PLL was contemplated. So it's not so much about the students who are now graduates, but it's more about the prospective students relying upon the committee to have checked that the school is doing all of the things that you've asked it to do at that point in time when it reported in July 2020.
And to make a comment, Natalie, you took the words out of my mouth essentially. To really boil it down, it does not impact the actual law students or soon-to-be attorneys if they pursue the program. It only impacts the law schools in showing their statistical numbers of saying or showing that they're a better law school, etc., etc. My main fear, I guess, if we really follow what the 3 law schools have wanted, is it will dramatically change all the statistical numbers of all the other law schools in California, and it will essentially show almost 100% bar passage rates. Because no one, I mean, of course you have to get 1390 plus the 300 hours, but it will dramatically increase the numbers for law schools to advertise to people. I just don't see why we should be providing more deceptive-ish numbers than it should be. That's my opinion on that. I think, I forgot who was saying, I think it's Donna. We have to definitely recalculate how we should be presenting these numbers moving forward as long as the program is in place. But coming back, this is just an attempt to inflate numbers by law schools, in my opinion. That's how I'm seeing it, and that's what I'm gathering. And this does not impact the actual applicants or people who got a 1390 and doing that 300 hours. It may impact them by the law school's credibility, like if you attend a quote unquote go to bad law school, but that's my opinion.
Okay, thank you. So Paul and staff, as well as the other members who did the inspections, thanks so much. And per Paul's comments before, when we're taking a vote, as well as the motion that somebody will give, it's on the 3 schools, JFK School of Law, Lincoln Law School, as well as San Francisco Law School. Is there a motion?
And that would be to
Yes.
adopt the amended motion.
This is Robbie, and I'm sorry, Paul, did we decide, can we take the 3 of these collectively?
Yes.
Yeah, I think
Okay, then
so.
I'm going to move to adopt the staff recommendations as to these 3 law schools.
This is Michael. I'll second that.
Seconded by Dr. Cow.
Yes.
Ms. Wong, can you take the roll?
You're muted, Kim. You're still muted.
I'm muted.
No, Kim is. You're fine, Dr. Bolton.
Kim, I don't think you're muted. I think your volume is off
Oh,
for your speaker. We can't hear you.
You may have to shut down the program and reopen or restart the computer. Could be just hardware configuration not picking up to the software, etc.
Or are you saying she just didn't hear us to know that she's supposed to start?
She can hear us, we just can't hear her. Devin, do you want to take the vote?
Hello, can you hear me?
There you are.
yes. Yeah, there you are.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Nay.
Ms. Heisinger,
Yes.
Mr. Isari,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Vice Chair, Mr. Lawrence,
Yes.
Ms. Peak,
Yes.
Judge Toriaba,
No.
Mr. Reyes,
Yes.
Mr. Torres, and Dr. Wilkinson.
Yes.
The motion passes.
Thank you. Open item 403, administrative updates from accredited and unaccredited law schools. Paul?
Yeah, unless Natalie wants to highlight something in particular, this is just informational. Does a motion say receive and file? I don't have it up in front of me.
Sure. Basically, it's an administrative update. So we have Dean Myron Steeves becoming permanent dean at Trinity Law School. We have a new dean at American Heritage University Law School in Rancho Cucamonga, and that is Rosa Mosley. We also received late breaking notice that there has been a change at Pacific Coast University, a school that you've worked with several times this year, that they have retained their current dean, but adjusted his time from a full-time status to a part-time status.
Okay, and there is no need for a motion here, so unless there are questions, we'll move on to our goals.
Sure, go ahead.
Okay, so Natalie, there's a bit of a PowerPoint to discuss some of the things that are upcoming for us. Do you want to go through that?
Sure, I'd be happy to do that. Let me pull it up now. Oops. Thank you. It's actually just a 2-page slideshow. We just wanted to make sure we got a couple of important key points up. The first one is to make sure that everyone knew that the accredited law school rules revision was adopted for approval for public comment posting. So it's up on the State Bar's public comment website. You can take a look at it through February 15th. And I have been monitoring the public comment that comes in, and actually we have not received any yet, but if we do, I will be sharing it first with your Ed Standards Chair and Vice Chair, Paul and Dolores, and if necessary, bringing it back to the committee. I apologize for that date. It is actually March 18th that the Board of Trustees will review the public comment and may take action at its meeting. And the CS BARS is already starting to think about potential guidelines that might be needed to accompany the rules, understanding that, of course, if the rules are adjusted in any way by the Board of Trustees, they can be modified appropriately. And then also just to recap, as we let you know in December, we did have our annual law school meetings via Zoom. In the past, we held those meetings one north and one south. And this is the first time we did it on Zoom. We got a lot of very positive feedback. And these are terrific conversational meetings. And I'm very happy to say we didn't lose that element when we went to Zoom. A number of changes were made in or directly after that meeting that we think were helpful for the schools and ultimately students. Most notably, adjusting the status markers that are in the applicant portal when a student is applying for an exam but waiting for certification of their completion of requirements with schools. There often was some confusion about the prior wording. The new wording, I understand, has already greatly reduced the number of student questions to the State Bar and also the school. In addition, Audrey mentioned earlier the e-blasts that are sent out every week, and we've been able to distribute those more widely, including to directors of academic support and bar support, so that we've got the law school community working with us to help keep the graduates and applicants informed. So I think it was a very positive experience. In addition, you know that the Supreme Court directed that for those students in largely registered unaccredited law schools that are required to take the first-year law students exam on very short notice. The exam moved online due to the pandemic in June. And because it was the first time it was administered that way, the Supreme Court directed that those students for whom it was their first, second, or third opportunity to take the exam should actually have an extra opportunity, 4 opportunities, to take and pass that exam and claim credit for all of their study to date. And in order to do that, there needed to be a statutory change, a change to the admissions rules that apply to students, as well as changes to the accredited and unaccredited guidelines. And all of those have been completed and posted. And then finally, the Law School Dean's e-newsletter will be issuing next week to the registrars and deans, as well as to Paul and Dolores, who will bring the highlights back to this meeting. So that's my update.
Any questions? Okay.
Great, thank
I
you.
gave Natalie one typographical correction to the goals. The only other
It's in
thing I'll
there.
note
I mean,
is,
it's corrected.
okay, in the last goal, it talks about the possibility of reviewing the registered law school rules this year, but given the other work we have, I don't think we'll get to that, but maybe that'll be for next year, but we'll see. So the appropriate motion would, unless there are questions, would be to approve the goals.
Yeah, this is Robbie Brody. I'll move to approve the goals, and thank you, Paul and Natalie, for our new member. Boy, this is the hardest working committee, the Committee of Bar Examiners, and the work is so important with our role as guaranteeing public protection. We are really ensuring that students, prospective students who look at these law schools are getting what they are told they're getting. I mean, it's so important that the schools provide what they represent. They will provide, and this work under Natalie is just, it's fantastic. So thank you. I'm so happy to support those goals.
Great.
This is Michael,
Thank you.
second motion.
Great. Ms. Wong, can you take a vote?
Sure. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora, Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Vice Chair,
Yes.
Ms. Pick,
Yes.
Mr. Rios,
Yes.
Judge Toriaba,
Yes.
and then Dr. Wilkinson.
Yes.
The motion passed.
Kareem is a yes too.
Thank you.
Thank you, Ms. Wong. So we're going to move on to moral character with the chair, Bethany Peak, to talk about moral character goals.
Yes, so like all the other goals, we already went through these during the presentation earlier. So you guys know what they are. We've completed number 1. We're going to have this follow-up presentation for LAP in our next meeting, and then there'll be additional trainings on moral character determination topics, as well as our last one, which is conduct requested administrative reviews of moral character, which is just what we do. So unless anyone has any comments or edits, does anyone want to move to approve the goals?
This is Robbie. Oh, I think somebody,
Yeah, Dolores, I'll move.
oh, and Dr. Cow wanted to second that motion. I have to defer to that guy.
Okay. Thank you, Ms. Wong. Can you take a vote, please?
Sure. Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora, Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Vice Chair,
Yes.
Ms. Pick,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
and Dr. Wilkinson.
Yes.
The motion passes.
Kareem's a yes too. I'm so sorry. My daughter's distance learning, so I apologize.
Thank you.
And Mr. Chair, I have one question, if I may. So during public comment, one of the attorney applicants had mentioned something about our process for people who've been denied and whether they can continue to practice in the interim while they're appealing that decision to the committee. I was wondering if we could, for a future meeting, agendize that just to review that policy. I don't have an opinion either way, but I just wanted to know if we could raise that to discuss at a future meeting.
Sure. I don't see any reason why we can't.
Okay, thank you.
How could they
Thank
be
you.
practicing if they were denied? Or is that, you're talking about people provisional licensure?
This was an attorney. It was an attorney applicant.
Oh, I see. Okay.
And I think it was for international or out-of-state attorneys specifically. Something like that. I think that person wrote a comment, but I might be mixing up people.
Okay.
I
So
believe it was related to registered in-house counsel who receive a negative or adverse moral character determination and are wondering if they can continue to practice as registered in-house counsel pending a final determination on it by the committee.
That's it. And in-house counsel is usually out of state or international.
Thank you.
Okay, thank you. I see we have staff back for an O&M report. So going to go back to operations and management for a report on the October 2020 California Bar exam cost analysis. And I asked Judge Torrealba to sit in for me while I was serving in the vice chair and the chair duties right today. So Judge Torrealba and Tammy Campbell.
Well, Tammy just texted me, so I presume she's back and ready to give her report. So with no further ado, Tammy, are you ready?
Yes, I will start on the cost analysis and then we can do the O&M goals after that, right?
Perfect. Yep.
Okay, perfect. Okay, so the October 2020 California bar exam cost analysis. Of course, just like June, because of COVID-19, we had to change the modality of the October exam. So instead of the majority of our applicants being in person, the majority of our applicants were online this time, with a smaller group of applicants who were in person for testing accommodations and extenuating circumstances. The cost analysis has historically focused on the overall cost to administer the exam in person at the test centers. Data that we had previously been provided over the years did not factor in other costs such as printing exam materials, MBE booklets, graders, the laptop license fees, or other indirect costs that include all of the staff time to prepare for these exams before, during, and after the exam has concluded. This exam, of course, included the process of us reviewing flagged videos. So rather than us observing everybody in person, we were observing people more online and looking at flagged videos, which I know Audrey had already done a presentation on that a little while ago about the Chapter 6 process. For this October exam, we ended up spending $2,729,000 on this exam for 9,301 applicants. That compares to, for July of 19, of course, because July is what this exam was supposed to have been, we had 8,206 applicants and we spent $2,298,000 for that exam. There was a change in the number of applicants where we had an increase this time of 13.34%. So there's a difference in how many applicants we actually administered the exam to. Some of the highlights, I'm just going to go over a few of them that I had listed in the agenda item, is that there was a lot of shift in some of the costs for the October exam based on the change in the modality. We had less test centers that we were paying for this time around than what we normally do. But on the other side, for what test centers we did have in person, we did have applicants 1 per room, which is not our standard. Usually at a testing accommodation site, we will have 2 people per room, and some rooms still accommodate upwards of 10 to 15 people. Because we had less proctors this time around, you know, it was a little challenging because of the fact that we had 1 proctor monitoring 2 rooms close by. So that way we could reduce exposure due to the pandemic. And then of course, we also had some other changes in costs, such as we had less printing and less cost for the MBEs because more people were doing it online. We had the addition of the exam ID and exam monitor fee for those online applicants that we added to this exam. And then we had the elimination of audiovisual, tables and chairs, electrical and coffee that we provided for proctors in February because of the fact that we didn't do it in person and we couldn't congregate in a room together, of course. And then there was also the additional cost of buying a large volume of personal protective equipment, such as hand sanitizers and face masks and plexiglass, so that we could put plexiglass up to have a barrier. And then, of course, because we didn't want applicants congregating at a water station, we had to shift to bottled water, which a majority of our test centers, of course, charge for bottled water to us. And that was an additional cost because we couldn't just put up a water station like we normally do at a testing accommodation facility. The exam also has included the fact that we did have less people in person. So for example, with the bar exam, for this exam, we had 381 applicants only taking it in person. Compared to July 19, it was 540. Because of that, it basically costs us to administer the exam to those applicants in person approximately about 35.8% of the total exam cost this time versus 49.5% for the July 2019 exam. And then, of course, looking at July 2019, it cost approximately $278 per applicant to take the exam at an in-person non-testing accommodation site, and $2,942 for a testing accommodation applicant. However, for the October 2020 exam, it was approximately $145 to administer the CBX to applicants taking the exam online this time, and approximately $2,332 for each applicant that did it at an in-person test center. Those figures that I just gave did not include the cost of graders or exam-related consultants or printing or anything. But when I factored in all those other additional costs that were a little bit harder to break down as a by applicant at that point, it was more of like, this is the grading for the whole exam. For example, the overall cost per applicant in July 19 was $280, compared to this exam with those extra costs incurred $293 per applicant. So that kind of gives you a good comparison on how things looked between July 19 and October 20, which was done mostly in an online remote exam environment. And so with that, that's all I have to present. From there, any questions?
Yeah, I have one, which I'm asking you to speculate, okay? Assuming that the future is going to probably be characterized by hybrid exams, right? In other words, some kind of maybe not as remote as this one was, but there may be elements of it or whatever. How do you see the long-term cost being?
So not knowing exactly where our future is going to go with how we administer this exam, if we were to continue in the process that we're doing right now, that's the one I can base it on. And let's say we're past a pandemic at that point. Obviously, our testing accommodation sites are going to go back to doing more applicants per room. So that makes a difference where now the amount of rooms we have will accommodate more applicants because we're not trying to social distance. Of course, you'll reduce the PPE. We'll go back to doing in-person orientations with our proctors. So it's really hard for me to say where exactly everything would end up on a financial level without really trying to sit down and do this huge breakdown of everything further. But for me, I'd say you'll see some adjustments on both sides with the costs. And in the end, maybe we'll spend a little more than what we're spending right now. But again, it's hard for me to really say that without doing that and knowing what it looks like for the future.
No, that information was really good. I think great job, Tammy, as always. We have to take into consideration when people are in individual rooms that that is going to cost a lot more. So I mean, I would venture to guess that it would be about the same, if not maybe, a little bit less. But we're talking, I mean, you're talking basically $15 difference per person doing it the way that we did in 2019 to 2020. So it seems like it's pretty, it seems like it would be more cost effective, but there's still a lot of in-person stuff that needs to be done. So it will remain pretty much the same in terms of cost analysis.
Might be able to save money for not having to rent those huge convention center halls, that type of thing.
Okay, so that just brings us then to the goals.
Excuse me, Judge.
Oh, yes, I'm sorry.
The motion to affirm the report to receive.
Sorry, I forgot. Yes, please. Do we have a motion for that?
Yes, I'll move to receive the report. This is Robbie Brody.
And a second, please.
Second.
By Chair, is that Mr. Lawrence?
I think it should be someone else. Is there a second?
I would second that.
Thank you. Let me take a roll call. So Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Mr. Vice Chair,
Yes.
Ms. Pig,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
and then Dr. Wilkerson.
Yes.
The motion passes.
Okay, so now we can go on to the goals and high aspirations of operations and management. I think it's pretty self-explanatory. Tammy, would you agree? I mean, there's nothing earth-shattering in terms of changes for 2021 from 2020.
Not a lot of changes, nothing earth shattering. The only thing would be, and I think I pointed out in the planning session this morning, a few of those dates were based on winter 2021 of us doing things. Those are going to have to be adjusted and moved back based on circumstances to complete some of them. But other than that, nothing out of the ordinary.
Great. So with that, is there a motion to approve the goals of operations and management?
This is Robbie Brody. I'll move to approve the O&M goals.
This is Kareem. I'll second.
Thank you.
Dr. Bolton,
Yes.
Judge Brody,
Yes.
Dr. Cow,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes.
Mr. Kramer, Vice Chair,
Yes.
Ms. Pig,
Yes.
Mr. Reyes,
Yes.
Judge Toriaba,
Yes.
and then Dr. Wilkerson.
Yes.
The motion passes.
And add Kramer as a yes.
Thank you, Ms. Wong. So I believe that concludes all of the items for the open session. So I would like the committee members and State Bar staff to leave the open session and join the closed session. You should look for an email from Ms. Kim Wong with the subject line closed session that will have that information. So we'll see you in the room shortly. Thank you. Welcome, everyone. I see people are just still filing in a little bit. So meeting business has concluded. Again, just want to ask if there is any more business. Great. Thank you, everyone. enjoy the rest of the day and have a fantastic weekend. Take care. Bye-bye.
Thank you.
Thank you.
Bye-bye.
Bye, everyone.
Thank you. Bye.